the hearing on the Children and Family Law Committee. How about we all do the pledge together? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning, Mr.
At
Chairman.
this time, we'll now open the public hearing on House Bill 178. At this time, the chair recognizes Representative Nancy Murphy.
Good morning, Mr. Chairman. Thank you. And honorable committee members. For the record, my name is Nancy Murphy. I represent Hillsborough County, District 12, the town of Merrimack. Happy to come before your committee today relative to subject matter, special education and foster parent, that have impacted my own life, both for personal and professional reasons. As a former foster parent and adoptive parent of children with disabilities who've received special education over the years, and as a result of my experience in my former professional role at New Hampshire's DCYF, I recognize the value of committed foster parents in educational decision-making for children in their care who are without legal parental parents to fulfill that role. I also recognize the need for special education laws to be written in a way such that to limit confusion and to make the intent clear. It's likely that for that reason that Ms. Bonnie Dunham, a constituent in Merrimack with a great deal of experience and expertise in special education, requested that I file this bill relative to clarifying some confusing language in New Hampshire's special ed statute, RSA Chapter 186C, Section 14A, Paragraph 1. Ms. Dunham should be here and plans to testify, but it's actually pretty simple. Though HB 178 addresses statute relative to appointment of foster parents to make educational decisions on behalf of a child in their placement, it changes nothing substantive about the policy. It merely removes confusing, redundant language to better clarify the statute's meaning. As you can see, that he or she has the knowledge and skills to represent the child adequately in services appears in the introductory sentence of the statute. The same phrase is included in subsection 4. As written, the introductory sentence is confusing, and given it also appeals later within the same section, is redundant and unnecessary. HB 178 simply seeks to remove those 16 words so that the statute's more clear. Thank you.
Any questions? Seeing no questions, thank you for your testimony.
Thank you.
This time the chair recognizes Representative Markell.
Thank you, Mr. Chairman.
Good to see you.
Good to see you. Thank you, sir. Good to see you, Senator. Good morning. Good to see you again, Senator. My name is Jay Markell.
Turn your mic on.
Oh, sorry. Yes. My name is Jay Markell, and I'm a representative from District 18 in Rockingham. Generally support the bill. One question is whether or not parents, if the children are in foster care, whether or not this should be amended to include the fact that they are not the sole and exclusive rights to determine education, because if they're in foster care and unless parental rights have been terminated, even children who are in foster care, parents do not lose all of, even in their foster care, parents do not lose all of their rights. So what I'm thinking of is that unless they're specifically excluded, the committee might want to think about amending this and make it in conjunction with consultation with the parents. I'll be happy to take any questions.
Thank you for your testimony. If I may ask, although I appreciate what you're saying, should that maybe be better served as a standalone bill?
It could, yes.
I don't think that policy is something we have thoroughly discussed. It wasn't discussed in the House, I imagine.
Oh, okay. I'm just talking about what I have here in front of me.
Representative Senator Sullivan.
We're having a rough start to this day today.
Sworn
Thank you,
up.
Mr. Chairman. Thank you for taking my question. So I read it as a foster parent or parents may be appointed.
Right.
So I think that that covers, so they wouldn't be given that designation if the parents were still a part of the picture. That's how I read it, that although, you know, they have biological parents that may have some rights, this may also be part of the care of the child, sort of the network around them.
Well, the only thing I'm thinking of is that it's not absolutely clear to me, based on this statute, that it's to the exclusion of the rights of the natural parents.
Yeah, I don't, it doesn't mention exclusion of the
Because it just
the
says they have the
parents.
right to do it.
Yeah.
Yeah.
So, all right, but I thank you.
Okay, thank you.
Senator Long.
Thank you, Mr. Chairman. Yeah, I see your point. I agree with Senator Abbas that another bill, because it would depend on if the child was in the same district. I can see the complication there. But if the child went to another school district, then I would see the problem with having the parents that aren't involved currently making those decisions.
Okay.
Seeing no further questions, thank you for your testimony.
Thank you.
Are there any members of the public who are present who wish to testify? That, seeing none, we'll now close the public hearing on HB 178. Is there a motion to go into executive session?
So moved.
Second?
We're now in executive session.
I make a motion of ought to pass on HB 178.
Second?
Any discussion? Seeing none? All those in favor say aye.
Aye.
All opposed? The ayes have it. Anyone move?
Move consent?
So moved. Second, sorry.
All in favor?
Aye.
Aye. All opposed? The ayes have it.
I can take it out too if you want.
Senator Long will take it out.
I move to come out of executive session.
Second?
All in favor?
Aye.
Aye. All opposed? Ayes have it. We're now out of executive session.
So that's not 6 minutes. So, a bit fast.
Joshua's the master of time.
The clock underneath the stairs? Oh, yeah. The clock with the hands, I know you guys are used to digital things, but that's the.
You got any, did they just deal with this in finance? No big deal? Senator Gray's fine with this squeaky?
You can start. You have permission from the boss.
At this time, we will now open the public hearing on HB 177. At this time, the chair recognizes Representative Murphy. Welcome back.
Thank you, Mr. Chairman, and honorable members of the committee. I've actually provided a copy of an amendment to 177, although I'm not really sure that I need it. It's what OLS provided me yesterday. This again is really, it's a clerical issue on this bill. Sort of the long Reader's Digest version is that this was filed again at the request of a special ed advocate who discovered a need to clarify some language relative to RSA 193:27 pertaining to episode treatment. What happened was, background, 2 bills passed in 2024 that both made changes to the same paragraph of RSA 186C, New Hampshire Special Ed Law. They didn't conflict, but made different changes to the same paragraph. So HB 1511 took effect in July of 2024 and added 193:27, 27, Roman numeral 7. And HB 1639 took effect in October 2024 and did not include 193:27, 7. So I had reached out to, wasn't showing up on the website, and so I reached out to OLS. OLS said yes, because, there was that overlap, and the same paragraph was affected. The only way that could be fixed would be to file a bill. So I filed the bill, and, at that time, from July to October, 193.27 was not included in that RSA. It was included, excuse me, and then it disappeared. So the 177 passed the House on consent, and then we noted recently that it suddenly reappeared on the website and in statute. And I talked to OLS, and OLS has informed me that Thomas Reuters, I guess, integrates the bill at some point, and because there wasn't a conflict, there was that overlap, but now 193.27.7 is back in, and it's, I guess, to stay. And then this will only remove, so the bill that you have will only remove the word "or" before 169D. So I think it's line 6. So it will just take that out, because that was what happened when the bills sort of were in that limbo state. So really, it's removing the word "or." And
So-
I don't actually see the difference between the amendment and the bill that's filed.
So let me get this straight. Two great bills were signed into law that amended the same RSA, and as a result, one, although inadvertently, perhaps, superseded the other one. And you recognize that. Thank you for recognizing that. And then you decided to fix what was inadvertently superseded, taken out.
Correct.
And as a result of that, you put this in, but apparently it's been fixed somehow on its own. It doesn't matter how it's fixed. So I guess, do we need to pass this in order to address the fix? Or what happens if we don't pass this?
Well, I think it may be fine. I think 193.27 will stay, although it was concerning because it was there, it disappeared, and now it's back. But I understand, according to OLS yesterday, that's a matter of the integration that Thomas Reuters does before it's publishing. So this was the overlap and a little confusion because one did not conflict with the other. It didn't mean that it disappeared. It just temporarily disappeared from statute. So really, because now that change is back in there, 193.27 is back in, now we have the word "or" in two places, and it just doesn't read properly. So OLS suggested that we just remove the word "or" between 169D. So it literally is taking out the word "or."
The ors and the ands and the mays and the shalls all matter, so.
Yes, yeah.
All right. Senator Long?
Thank you, Mr. Chairman. Yeah, so I see the amendment that I have here is the same as as introduced, correct?
I believe so too. When I talked to OLS, they said, we're going to give you an amendment, and I said, I don't understand, because in the original bill, we made that same request when we were putting that section in, and that's what they provide. So in my mind, I don't believe we need the amendment, but that was what OLS provided based on our discussion yesterday.
Okay, Paul, if I may.
Follow up?
And in the bills that passed in '24, 193:27.7
Yes.
was in those bills.
It was in 1511, but it was not in 1639. So that's what happened. 1511 took effect first, so it was there. And then when 1639 went into effect in October, it disappeared. So that's why OLS said, we just can't put it back. We figured that was probably the intent, but you have to file a bill. So that's why 177 was filed initially. And then somehow, in the magic of integration and publishing, it now is back. But it has, because it was added on, we have the word "or" and then the statute and then "or." So we just now, hopefully, the end would be removing that word "or" and the statute will be correct.
Okay, thank you.
Thank you.
Well, I'm looking at the RSA right now, and there's way too many ors in there. Or I see.
So, but this is already in there, right?
that's in there, but
Okay, so,
we're just getting rid of
Yeah.
that or
Yes.
and keeping the comma. Senator Sullivan.
Thank you. So I think that the amendment is simply getting rid of the italics, because the amendment is usually, the bill is usually italics what's changed, right? Because 19327 is still, is currently in law, I think the amendment just gets rid of the or and gets rid of the italics, because that's not actually being changed. So I think that's
That's
just
why.
a
Yeah.
technical change.
Thank you. Yeah.
So if it's italics in the bill, will the law or RSA then have it in italics as well?
No, but it might have 9327 in there twice, because it looks like we're changing, we're changing it. So we'll go with the, okay, want to go into it? Okay.
No, I don't think we need I don't think we need the.
I think it's just, I think that OLS just did as a technicality, because when anything's bold or italicized, it means it's a change. And it's actually, that part is actually not a change, that's an existing law. So the only change is or.
Exactly. Yeah.
Oh, I understand.
I think so.
So we do need to adopt the, okay. Any further questions? Seeing none.
Thank
For your
you.
testimony. Are there any members of the public who wish to testify that have not testified already? Seeing none, we'll now close the public hearing on HB 177.
I'd like to make a motion to go into executive session.
Second?
All in favor?
Aye.
Aye.
All opposed? We're now in executive session.
I'd like to make a motion to pass on HB 177.
Is there a second?
Second.
I'd like to introduce amendment,
Wait,
oh,
oh, no, we don't vote on the auto pass, so you want to offer an amendment?
yeah, I'd like to offer amendment 1729H.
Second?
All right, all in favor of adopting amendment 1729H?
Aye.
Aye.
Aye. All opposed? The ayes have it, so the motion's now ought to pass as amended.
Yep.
Any
Okay.
further discussion? All in favor of ought to pass as amended?
Aye.
Aye.
All opposed? The ayes have it. Motion for consent.
So moved.
Second?
All in favor?
Aye.
Aye.
All opposed? The ayes have it.
I make a motion to come out of executive session.
Um,
Oh, I'll take it.
Okay.
Senator Sullivan's taking up. Before that motion,
Okay.
what's our next time? Never mind. Is there a motion to come out of executive session?
So move.
Second.
All in favor?
Aye.
Aye. All opposed? The ayes have it. We're now out of executive session.
I might say that this is the most efficient committee in the Senate.
Just remember that. Count on you. We have bills in the House. We're watching.
So we have till 10. Do we have anything else to
No, 9:50.
Oh,
At this time, we'll now open the public hearing on HB 132-FN. Here to introduce the bill is Representative Ladd. Floor is yours.
Well, good morning, members of the committee here and Mr. Chairman. I'm pleased to be here in front of your committee, and it was a pleasure driving down here on this wonderful sunny day when I should be working in my garden. So here I am today. For the record, my name is Rick Ladd. I come from Grafton County 5, that's Haverhill. And I'm here today to introduce HB 132. And HB 132 was heard in the Judiciary Committee in the House, and it's relative to the liability for family support under RSA Chapter 165, Aid to Assisted Persons. This bill came about, and the sheet that I've just sent around to you, the RSA that I'm speaking to is on the back side of that sheet, and it's worthy to look at that. The amended version, which you're seeing that came in from the House, is going in the direction that we need to go in terms of this bill. I was contacted earlier, late last year, in this session, by an individual down in Piermont. Piermont's a small town in my district. It's approximately 700 people living in it. And it's in between Hanover and Haverhill. This individual received in the mail from their town a letter stating, "You shall pay X number of dollars to support this person who's related to you in your community." And the person who was related, and of course the definition within the statute you have there says, if you are a father, mother, stepfather, mother, son, daughter, husband, or wife to a family member. So this person was a family relative that met this criteria in Piermont of an individual down there which she had not talked to for 30 some odd years, who is known to be selling drugs in the particular community, who is just an individual that had just gone off the deep edge and had not done much to help himself or herself. I won't get into the nature of that. And so, but she received this letter stating that law, which you're seeing right there in that RSA. It says if your select board member or your commissioner or somebody that's working there in your public welfare department determines that your weekly salary is able to sustain both yourself, but also to offer relief to that individual who is the one that's needing this relief, then, and if that goes, and it goes right down through the court system, you can be thrown in jail for 90 days if you don't provide that support. This bill came out of, this legislation or statute you can see came out of the 1920s. And when I went in and talked with the people down across the aisle here in legislative service, they said, wow, something like that's still in effect? And I said, yes. And, you know, I have an older person that's been threatened in Piermont by their municipal government that you shall pay or you're going to end up going before a court system, and they may decide that you are going to go to jail for X number of days. That was pretty shocking to that individual. It was shocking to me when it was related to me. And so I said, well, we'll try and put legislation forward. My legislation was to delete the whole chapter of law, period, delete it. Judiciary did look at this, and it came out of that committee, I believe, 13-5, in support of the amendment which we have here. That amendment that you have in front of you today says this: if aid will not be held due to the failure of a legally liable relative to respond to the welfare administrator in the town or to provide aid. So this is lightening it up. So if I, as the relative that's being asked to fork over this dollar or this support, if I refuse to do it, that's the end of it. It takes out all that other or statutory language where you then go through the court system and you could be thrown in jail, which is really a pretty threatening thing. It's a heavy hammer for anybody to have to receive, especially when you're not familiar with the statute and all of a sudden you receive this letter in the mail. Whoop, if I don't help Freddie down the road here, I'm going to go to jail, even though I've been helping my own kids and I've been helping, get my grandkids through the NHTI or some other school, and I just don't have this wherewithal that's available for them. I'm using towards our family, that's my direct family here. And so it was changed, and any town or city furnishing aid may seek reimbursement in this format, but they won't go far they can't go any further with the court and the threatening of that. And the town is the one which would have to try to seek relief through their welfare department. So that's how this all came about. To me, when I heard there are certain organizations within our state saying, wow, we need this hammer. Many of those that are supporting the municipal associations, all that, we need a hammer like that so we can get this revenue coming into the town. This is not the way to do it. The way to do it, I think, is the way that the judiciary came up with this recommended language that you see in front of you right here. So I'm good with the recommended language. I was really concerned about keeping in law that reference to all that in the middle that's been struck out there, where you can see that the person could be, go through the judiciary system and end up locked up if they refuse to pay. I'd be glad to take any questions.
Joshua, do you have I have only in my, as introduced. Is there a copy of the amended anywhere? No, I realize everyone else is prepared. It's me who read the wrong version.
I think there were copies over here on the side. That's-
If I could ask one question, even though I clearly read the wrong draft of this, has anyone ever been arrested and actually prosecuted for this, or any?
I can't tell you that, Senator. I know that there was discussion that within the judiciary folks. I think it's language which has been, they prefer to see left in here from the municipal side, from the elected officers in your communities and all their organizations saying, hey, we need this. It's just that little threat that then we're going to get this revenue coming in, which is going to offset what we have to, do through the property taxes. But I can't answer your question on that. I don't have that information.
And I see what has actually changed, or being stricken from the law. Are there any concerns about perhaps unintended consequences? I mean, couldn't families just pass the buck now? And if there's no teeth behind the law, I mean,
Well,
why
Senator,
pay for funeral service if there's no?
that same question was asked in the judiciary to me, and afterwards by people on the judiciary. And I come down, I guess, from the understanding that I am not that person's guardian. I am not that person's responsible for that person's choices that he or she makes. Why should I then, who have tried to walk life properly and to support the choices that I'm making, to support my grandchildren, to support my children, to support my livelihood, why should I then be over here taking care of a brother or a sister or a mother or father that I haven't spoken to? I don't know if families are a tough thing to understand. There's all kinds of loving families, and there's other families, they're like the Hatfield McCoys, that don't even talk with each other anymore. And why should you then be responsible for helping that side? I don't get it.
But my follow-up is, so in the amended version, you can keep the changes that I suppose lines 15 to 20, right? And that, I think, addresses the scenario you encountered.
Yeah, they may seek. Yeah.
What I'm talking about is, well, let's say they had a relationship with this family member, but just makes a financial decision saying, well, if we don't really want to allocate any money to that, they're passing it on now to the town and there's no teeth behind the law to have them do something. I think in the scenario you referenced, it sounds reasonable, but suppose it's the other way around. I guess there's no, I feel like you can pass the expense on every time to the community if you just choose to do so.
I, as the relative, am not passing an expense that I've accrued or myself. It's not something I had anything to do with, and just because I happen to be related to this person, should I have to carry that person's burden? I think there's a line there where my responsibility starts and stops. And I think that this is something that probably came out of the Dust Bowl era and prior to World War II, and it's a carryover. I think our society has very much changed. And so therefore, I was really concerned for the way this was handled within the community that I represent. That individual was totally shocked. I'm going to go to jail. That's the response I got in the horn. I said, oh, calm down a little bit. We'll work this thing out. And so that's why we're here with this legislation.
Senator Sullivan?
Thank you, Mr. Chairman. Thank you for taking my question. Always a pleasure to see you, sir. So I have a question about what services are actually being delivered. So if a poor person has no relations or sufficient ability, the town or city in which they reside shall be liable for their support. So what kind of support is that the town, I mean,
Well, it's your welfare support that your communities oftentimes provide if they meet the poverty levels and they come in and say, I just need some help. And of course, in the town I have in Haverhill, that is listed as far as where our welfare monies are used. And we should be helping those which are, honestly hurting and need some help. They may have some real medical issues there. They may have transportation issues, and they may have housing. They may be forced out of the house. I know up in Haverhill, I've oftentimes, for those which are hurting, not even being a relative, would say, yeah, let's order a quart of wood for this bar. Let's call the fuel company up and have the tank filled. I've done that for people that are down and out in our town. I think there's better ways to handle something like this than this, turning it around saying, okay, because Johnny Jones over here, you're a distant relative or a relative as is identified in law, you are responsible. And I think there's other ways of handling this in a kinder, more current way. And this legislation right here harkens back to 70, 80 years ago, and that's not where we are today.
well, so for instance, somebody could go to your town and ask for help based on the guidelines that your town has. They deem that they are eligible for this help. They make the decision to give this person this help. And then they can go to some unknowing, unsuspecting relative and say, well, we made the decision to help this person, but now you're paying for that. Is that where we stand currently?
Well, I think that the interpretation of this law you're seeing in front of you that's on the books right now, they can do that. And if they want to force it all the way, now, I don't know whether the court system nowadays would do the ultimate, the 90 days or no fewer than 60 days in jail. That's pretty harsh. As Senator Sullivan, I like to call you representative. I remember you on the Education Committee. Wish you were back.
Oh, thank you.
But
Staying here.
staying here. Okay, but I guess I've explained as much as I can about this, why it transpired and why it's before you right now. And I think it's definitely the majority of the House that feels this way.
Thank you very much.
You're welcome.
Thank you, Mr. Chairman. Good catch, Representative. Now, my understanding is that the Welfare Association had input in this language. Can you verify?
When I can't tell you what happened after I introduced the bill. I was kind of caught up in a lot of the adequacy funding and all our issues. So I didn't follow this bill. I'm just following it now. It's back over here. I had talked to people. I talked to Representative Lynn and others, and they had came out with this, and I was satisfied with the way it came out here. I don't know if this is the total answer. My total answer would be to eliminate the whole darn chapter.
A follow-up, if I may. So my understanding, well, I spoke to the director in Manchester, and what they do is they do call these families, and they have been to court before on this statute, and they haven't won, because a family member will say, I haven't seen a person in 20 years. So I think this helps with that. What they currently do is they'll call family members and ask, can you give 10 gallons of oil, or can you give, a $50 certificate to Market Basket or what have you. And they'll allow the family to say yes or no. And then they'll assume the responsibility. So I think this, according to the director of Manchester, this puts in perspective what they're currently doing,
Senator, you're correct.
not being aggressive.
The way you just explained it is the way I would handle that. I would give a call to the individual, say, can you help? And 95% of those you call will help. And that's how we should work as a society. There shouldn't be this heavy hammer behind, if you don't help. I think that's wrong. And that's the part we need to get out of this law.
Very good, thank you.
You're welcome.
Seeing no questions,
Thank you very much.
Thank you, Representative.
Have a good day.
at this time, the chair recognizes Representative Markell.
Yes, thank you, Mr. Chairman, for taking it. One thing I'd like to do is change my status on this bill to supporting it from opposing it if I can. Let me explain a little bit about it. I have some familiarity with this kind of thing. The history of this kind of legislation actually comes out of English common law from Elizabethan poor laws. So this goes back to probably 300-400 years, okay, in terms of its history, when we borrowed a lot of our common law from England. A lot of what happens in this particular kind of situation is fact-dependent. What you heard earlier, I think, was essentially correct, that, for example, if you have a parent who is seeking support, for example, from a child who never supported that child, courts will take a look at that, okay, to see whether the parent had ever supported the child during the child's minority. They'll also look at other factors. That's my experience with this. The other thing is that if we could, I would support the move to basically delete this from law, if possible. And the reasons why is that a couple of reasons. Number one is that it's fairly easy to avoid liability in certain circumstances. And I'll give you an explanation for it. First of all, when we look at who's going to be liable under the present statute, we're going to find that it says the relation of any poor person in the line of father, mother, stepfather, stepmother, or son or daughter or husband or wife. First of all, your position as a stepfather or a stepmother can change with a divorce. And if you look, for example, under parenting rights and responsibilities, and there was a Supreme Court case on this in the last couple of years, and something I pointed out to the House Child and Family Law Committee on step-parent visitation with children is relative here, and it's on point. Because what happens when you have a divorce and the statute says is a step-parent? So what you can do is you can avoid liability by simply divorcing the person you were married to, and you are no longer a stepmother or no longer a stepfather, which means you can evade responsibility under this statute, because that's all you're going to have to do. Because then the burden would shift for the court to say something else, and how are they going to find something that's already in statute? So it says stepfather, stepmother, it doesn't say is or was. So that's one way of avoiding the responsibilities of it. The other things are that in terms of step, you're creating duties where none actually existed. For example, a stepfather has no duty, or stepmother, under absent extraordinary circumstances in New Hampshire, very extraordinary, has no duty to support a child as a general rule. So what this is doing is this is imparting a duty that doesn't otherwise exist. In addition to which, when you say is basically suggesting that the person is on public assistance, there's no differentiation here between disability and being unable to work, okay, or be self-supporting, or simply refusing to work and become self-supporting, which I think is contrary, should be, if not, should be contrary to public policy in the state of New Hampshire. So I not only have shifted my opposition to supporting this bill, if there is some way we can actually get this particular statute deleted, I would support that. Be happy to take any questions.
If I may inquire, so looking at the amended version, I'm reading this as, although it rewrites the existing law,
Yeah,
I'm not sure, when it comes to substantive changes, it still provides that any town, I'm on line 18,
right.
any town or city furnishing aid may seek reimbursement from any legally liable relative with sufficient means to provide reimbursement without financial hardship. So if they seek the reimbursement and they seek legal recourse,
Right.
and they get a court order, and
Right.
the order's not complied with, they'll be held in contempt, but this is erasing the contempt language from there.
It does.
So I guess if this were to play out in the real world,
Right.
the amended version, I'm looking at it as they still could be held in contempt. I guess it doesn't, the 60 to 90 days part might be taken out. Maybe
Could be.
They can make it a lower, but they still could be held in contempt. Is that-
Well, contempt is, contempt in New Hampshire is basically discretionary on the court and has been since this country was founded. So obviously, the question is, as generally speaking, as contempts are defined in New Hampshire, it's usually willful noncompliance in New Hampshire. Other jurisdictions define it differently, as Massachusetts does. So if you have noncompliance and you're simply unable to provide the support, you can be found to have an arrearage, for example, in child support or alimony cases, but are not in contempt.
So my follow-up is, if we take what's the existing language where, and this is on lines 13 to 14, but it's stricken. It says, he shall be deemed to be in contempt of court. If you just ended the sentence there and removed, and shall be imprisoned not more than 90 nor fewer than 60 days.
Right.
Could we just strike that language and leave the existing language?
You could do that. However, the interesting thing here is that the statute in this particular case, in my professional opinion as a practicing attorney, might be defective for a couple of reasons, and I'm not aware that this has ever been challenged to the New Hampshire Supreme Court level. But the reason I say that is because it blurs the line between civil contempt and criminal contempt. For those who are not aware, civil contempt is basically where there may be a willful noncompliance, but the alleged contemptor has the key to the jail cell. Because he simply is not in compliance with court orders, and once he brings himself into compliance, then the contemptor is basically freed from being incarcerated. A criminal contempt, differently, is frequently driven by the by the nature of the incarceration itself. So when you're under a civil contempt matter, what you're doing is you're saying, we're going to hold you for an indefinite period of time until you bring yourself into compliance with the orders. Criminal contempt usually has a finite duration to it. So a perfect example would be somebody like Steve Bannon, who was cited for criminal contempt, where he did, I think, 4 months federally for being contempt of Congress. So here you have a similar problem with this statute. So as I repeat, I'm not aware that this statute has ever been tested at that level. I think it has significant procedural due process issues, and I think it blurs the line between civil and criminal contempt. Number one. Number two, I remember years ago attempting a CLE where Health and Human Services typically gets involved in public assistance cases. And they had indicated that they have no real intention at that time, years ago, enforcing this particular statute. So here what we do is we're going to the county level. So, I regard this entire statute as basically a throwback to the 16th century. And I don't see it as being applicable today, and certainly not representative of a modern society.
Thank you. Senator Sullivan?
Thank you, Mr. Chairman. Thank you for taking my question. So
Sure.
part of my district is Manchester, and as you know, we have a very serious opioid epidemic there.
Yes.
What my concern, as with the law as it stands now, is that many families have had to make the harsh decision to sever relationships with their children because of addiction. They've given them everything that they can. So as the law stands now, those families could actually be taken to court and sued to support the family member that's struggling with addiction, right? That they've decided we can't give anymore. They've, for whatever reason, severed those relationships. They can still be held accountable for their actions.
Yeah, and I think that is problematic, particularly when you realize that there are upper limits to child support as it exists in the state of New Hampshire. So this doesn't incorporate any of that. So I think you're right. I think that's a very good argument for getting rid of the statute in its entirety.
Thank you.
Senator Sullivan?
That's me.
Senator Long?
Thank you, Mr. Chairman.
Manchester.
So on line 4,
Right.
their weekly income is more than sufficient. So not that it's sufficient, it's more than sufficient.
Right.
Telling me that if you got a mortgage, you own $1 million house, your mortgage is high, you need more than sufficient to be able to pay. And I'm wondering so let's take a hypothetical example of, I'm calling a parent on a $900 lease that welfare is going to pay. The person's looking for welfare to pay $900.
Right.
What would be the cost of going to court?
Well, that's a good question. I guess it depends on if you have an attorney, what's the attorney going to charge you, and how familiar are they with these kinds of cases? As a general, by way of answering your question, I'm going to say I don't know. Okay, but by way of factual inquiry, what defenses would I raise if I was representing somebody in this situation? I would take a look at their financial affidavit. I would look at their needs, their basic needs, and then it would be a question of whether they're able to contribute at all. So somebody could be earning $500,000 a year and still literally living paycheck to paycheck, which happens, and quite often. And even though that's a substantial income. So then it becomes a factual inquiry.
Okay, now follow up if I may. I mean, I should have asked the director of the Manchester's welfare this question, but I didn't think of it. Is this some sort of leveraging to call families?
It certainly, as it's written now, it certainly is. And, it may have been years ago that the state felt it needed cost containment if people were on public assistance. But today, we have the social safety nets that didn't exist, prior to the New Deal. And as I said before, this is basically derived from the Elizabethan poor laws of the 16th century, when none of those social networks existed. Given the rather simple way it is to avoid liability if you're a step parent, because this is so vague, just get a divorce and you're off the hook. Because you're no longer a step parent. And it also creates duties where none existed during a marriage. So I just think this statute is terrible.
Very good, thank you.
Tell us how you really feel. Seeing no further questions, thank you for your testimony.
Thank you.
At this time, the chair recognizes Todd Marsh.
Beautiful spring day outside. I became that person, I'm sorry. Beautiful spring day outside, and I'm mindful that you're in here listening to people like me, so I appreciate your service. My name is Todd Marsh. I am the president of the New Hampshire Local Welfare Administrators Association, and I certainly know Charlene from Manchester. And I appreciate the previous testimonies. I will state, to answer one of the questions, our association was not consulted with the initial writing of the bill. I think that our testimony at the House level may have influenced the amendment, but I'm unsure of that. So I am here on this beautiful day to support, as amended, HB 132 regarding what we know as the legally liable relative law. This law has been in existence, as was indicated, for many decades, and we believe that this change is a common sense and common ground update that maintains the local intent of the law while removing unreasonable language, including the word imprisoned, right? At a time of increasing local welfare costs to taxpayers, we agree it is essential to maintain the option to seek review of legally liable relatives' ability to reimburse for taxpayer assistance provided, and agree the update makes sense to maintain reasonableness. I will indicate that I appreciate the mention of that letter that was written to a family member. I will state that if it was sent in with those words, that was inappropriate, that was unreasonable. No letter should be sent to anyone stating you shall pay without any review of their ability to pay. So if that happened, it should not have happened. I think that type of practice is happening less. I think with the professionalizing more of what we do. So we would condemn that type of approach. And I do not believe that a city like Manchester, and I did speak to Charlene, she is on our board of directors. She's one of the board members that sent me here. I know Manchester would not send a letter like that. And also, I should also indicate that, as you are aware, brothers and sisters are not part of the legally liable relatives or distant relatives. I will state that enforcement follow through with the law is not frequent. It just simply isn't. In Rochester, we've never used that directly. As simply citing the law often results in family assistance when possible. And I'll give you an example. And I want to be careful in getting into the weeds because I know I can. If a legally liable relative adult approaches our office or our offices, okay, for cremation assistance, that is one of the forms of assistance that we, under the law that we offer, for a parent. On our applications, we do indicate RSA 165:19, which currently does include the word imprisonment, and we welcome it not to be included. But if they approach us, the law is indicated on the application, and I would say, and have engaged my welfare board about in similar situations, I'd say about half of legally liable adult children returned to apply. Why? Because they look at the application and I think they say, oh, our finances could be reviewed to determine if we can more than reasonably afford for mom's cremation. And it's sort of a thought check. And if they do need it, they come in. And if they do need it, they come in for assistance. So we view it as, especially with the amendment, as improved reasonableness, a thought check, families first in New Hampshire, if possible, right? And the approach does matter. Again, nobody should be sent a letter or called stating, you might not have seen Johnny for 30 years or 10 years, but you need to pay or you go under jail. I think if that did happen at all, it's very rare. And certainly with the updated language here, the amendment, it shouldn't happen because the word imprisonment will be deleted. So we, as a welfare association, we absolutely appreciate some form of language existing to act as that thought check of family members' reasonable ability to maintain. I will add this, and I'm trying to be careful not to go too far into the weeds. There's a reality. If mom, dad, adult children live in, I don't know, Alabama, California, Washington State, there's only so much time that we have to determine to work situations. We are going to be selective, and does this make sense? Does this make sense? But it is a tool in our toolbox to use if we think that we should.
Senator Sullivan?
Thank you, Mr. Chairman. Thank you for taking my question.
Yeah, you're
So
welcome.
laws like this drive me wild because theoretically you have one person who's using welfare, and now you're going to have a second because if you imprison someone for 60 to 90 days, they do not have an income, right? So now they come out and now they're part of the system as a punishment for not helping someone that they didn't know or didn't have a relationship with. Is that accurate the way the law is written
I
today?
absolutely appreciate that question. In local welfare, we call it the art of welfare because we're not categorical assistance. It's about the numbers, but it's not all about the numbers. It is important to look around corners. If we do this, what happens? If we do this, are we harming a family? And are we spending even more taxpayer money if we do this? So in a situation like that, I'm not aware of any welfare official that would, and I also think that would do that. And I also think that according to the imprisonment aside, which would be deleted, I believe with the language of their ability to an income more than sufficient to maintain their needs, I don't see that situation happening. It's an art, and I very much actually enjoy working in local welfare because we need to think. It's not just about the numbers, it's looking around corners, what makes sense to do without being harmful to the person and to try to minimize costs to the taxpayer.
Thank you.
You're welcome.
Senator Long?
Thank you, Chairman. So with respect to this statute, what is the cost of cremation?
Well,
6,000?
my answer is going to be, it depends, but I'll try to give you an answer. The bills that we normally see, it can be that we're charged, that local welfare is charged, perhaps around $2,000 to $3,000. It could be more if it's in situations like this. I appreciate the New Hampshire Cremation Society and other funeral homes that understand the situations, and they're really providing these services at a fairly large discount. So it depends, but it's a reminder that life costs from before you're born, right? It's after you're no longer here. There's a cost.
Okay, another follow-up if I may. So I just want to be clear on what I heard is, I heard that and I'm thinking something that's $2,000 or $3,000, you cite this statute as to the reason why you're calling them.
Right, and that's if we call them. That's if we call them. It's the way it normally works is that we cite the statute on our application, all right, and we determine does it make sense to make a phone call? Does it make sense to send a letter? It does not affect, and I think you're aware of this, but it does not affect the person's assistance. This is a form of reimbursement, so which means it's after the assistance is provided.
Very good, thank you.
You're welcome.
Seeing no further questions, thank you for your testimony.
Thank you. Thank you.
Are there any members of the public who wish to testify in regards to HB 132? Seeing none, we'll now close the public hearing on HB 132. At this time, we'll now open the public hearing on HB 473-FN. Here to introduce the bill is Representative Nelson.
Thank you, Mr. Chairman and senators. It's very nice to meet you. Would you like me to change the thing? Oh. Thank you. This morning I'm introducing to you HB 473, criminalizing multiple forms of exposing children to controlled substances and allowing law enforcement to take a child into protective custody for screening and testing in an instance of suspected or actual criminal exposure to controlled substances. Thank you. This is amending RSA 639-A:1 that presently pertains only to methamphetamine exposure to add exposure to controlled substances, except those possessed pursuant to a valid prescription as defined by RSA into the human body. To give you a little bit of background as to how the idea to amend this bill came about, I received a call from a young woman, Tess, who I've known through the Legislative Youth Advisory Council, and she's here today and will testify. She wanted to talk to me about amending this RSA, and she, along with Alexandria Police Chief Suckling, convinced me that we needed to. I'm proud to be working with Tess, who's a terrific example of young people actively making change in the world. A little bit of history about this RSA, for those who weren't in the legislature at the time this was created. Current law pertains only to methamphetamine exposure, and this came about as a result of the methamphetamine crisis. The Federal Drug Endangered Children movement began in the early 2000s to respond to the growing phenomenon of finding children living among the squalor of meth labs located in homes and other areas where children were living or playing. The children found in these situations were often severely harmed or neglected, and in many instances tested positive for drugs. And most states passed laws nearly identical to ours. Since then, many states have expanded their drug-exposed child endangerment laws due to extreme increases in child drug exposure deaths and non-fatal critical exposures. According to an NYU national study, child drug exposure deaths in children 0 to 12 grew 900% from 2015 to 2023, with non-fatal exposures increasing 924%. Regarding children who have had serious medical incidents from illegal drug exposures, the media is constantly reminding us of this crisis. To note, here in New Hampshire, in the recent past, an 11-year-old and a 2-year-old both have had to have first responders administer Narcan to them, and thankfully they recovered. But unfortunately, not all children are so lucky. In the past 8 years here in New Hampshire, there have been 6 child deaths of children under 2 from accidental drug exposure. These children were exposed to fentanyl alone or a combination of fentanyl and cocaine or methamphetamine. In speaking with Chief Suckling and my own police chief, Fioli, and other people in local and state law enforcement, they're telling me they're looking for help to help children they're seeing in situations that can cause immediate harm or death. They want to be able to facilitate immediate testing to a child they suspect has ingested, inhaled, or absorbed any controlled substance through the skin, a drug or drugs that can cause irreversible harm or death. Give us the tools we need to help these kids, is what I'm constantly hearing from law enforcement. The real goal here is to enable the coordinated efforts of law enforcement, medical services, and child welfare services to ensure that the drug-endangered children receive appropriate attention and care. After me, you will hear testimony from Beth Sargent on behalf of Chief Suckling, who couldn't be here today. He's away on business. And you will hear what these law enforcement officers are experiencing in the field with children exposed to all sorts of illegal drugs and the real-life positive effects what passing this bill will mean. Thank you for your time.
Thank you, Representative. Question, Senator Long?
Thank you, Madam Chair. Thank you for bringing this forward. The only question I have is on the effective date. Is there a reason why the effective date is January of '26?
Thank you for the question. I don't know that answer. I can find that out for you if you'd like.
Okay, yeah, I just
Yeah.
wondered if there's somebody who needs to catch up before this is implemented. Or...
I haven't been made aware of that. Thank you. I don't know the answer. But I will email you. I'll find out and I will email you why OLS decided on that date.
Okay,
Thank you.
I just want to thank you for bringing this bill forward. We read these headlines way too often. And, you know, we're doing every legislative session, we're trying to figure out how we get a grasp on this. And this is just one step in the toolbox that we need to help kids. So thank you.
Thank you, Senator. And, you know, little bites of the apple will get us, you know, big change. So thank you. Appreciate it.
Seeing no questions, thank you for your testimony.
Thank you.
At this time, the chair recognizes Tess Summers.
Hi, Hi, Senators. Thank you. So, my name is Tess Sumner. I'm a senior at Newfound Regional High School, an advocate for child welfare, and also a member of New Hampshire's Governor's Youth Advisory Council. But today, I am not just here as a student or an advocate. I am here as someone who has seen up close how substance abuse shatters families and puts children in danger. I helped write this bill for my senior project, so I've spent the better part of a year researching the impact of methamphetamine and opioid abuse on children in New Hampshire. That research, along with my own experience, is what brought me here to speak in strong support of House Bill 473. This bill is a necessary and urgent response to a crisis that we cannot afford to ignore. In 2022, our state suffered 486 confirmed drug overdose deaths. Of those 486, 410 of those involved fentanyl. That means nearly 85% of those lost were tied to one drug. Yet our current statute, RSA 639A-2, only addresses methamphetamine when it comes to protecting children. This gap in the law has real, devastating consequences. Just a few recent incidents. In August 2023, a toddler in Londonderry died from fentanyl exposure. In September 2024, a 9-month-old in Claremont overdosed and required Narcan. And in October 2024, another 9-month-old in Charleston overdosed after coming into contact with drugs that were on the floor. These are not rare or isolated tragedies. They are clear signals that our laws are not keeping pace with the evolving nature of substance abuse in New Hampshire. Children are being exposed to substances that our statutes fail to acknowledge, and in some cases, they are paying for that oversight with their lives. Children are uniquely vulnerable to opioid exposure. Even trace amounts, whether ingested, inhaled, or absorbed, can cause fatal overdoses. And the consequences go beyond physical harm. Children growing up in these homes where drug use is present often face neglect, trauma, and other long-term developmental challenges. House Bill 473 offers a simple but critical fix, expanding the statute to cover all controlled substances, not just methamphetamine. This ensures that the law reflects our current reality of New Hampshire's opioid crisis, while still protecting valid prescriptions as defined under RSA 318B1. This bill is not about punishment, it's about protection. It also includes a provision to allow law enforcement to take a child into protective custody for medical screening when there is reasonable suspicion of drug exposure. This is not a mandate to remove children from their homes. It is a safeguard, a tool to ensure that children receive the care and support they need when they may have been exposed to a potentially deadly substance. It respects due process while also prioritizing child safety. New Hampshire has long prided itself on being a state that values family, community, and the well-being of its children. House Bill 473 is a chance to turn those values into action. This is not just a legislative issue, it's a moral one. We have the power and responsibility to act before another child is harmed by a substance they cannot choose or understand. Let us close this gap, protect our children, and make New Hampshire safer. I respectfully urge you to support House Bill 473 and help us ensure that no child is left vulnerable because our laws have failed to see them. Thank you for your time, your service, and your consideration.
See, no questions. Thank you for your testimony.
Thank you. You did a really good job.
And if you do have written testimony, you can pass it up as well. This time the chair recognizes Sarah Miller. This time the chair recognizes Elizabeth Sargent.
Hi, good morning. Chairman Abbas, members of the committee, my name is Elizabeth Sargent. I work for Champaign Capital Group. I'm here today representing the New Hampshire Association of Chiefs of Police. We are in support of this bill, and Chief Suckling is streaming this hearing as we speak, so he's asked me to do a good job. I've handed in his testimony. I'll try not to read it. I'll just hit the high points. Tess just did a great job. She actually shared some of what he said. I will tell you, he happens to be at a federal training on opioid and stimulant reduction in rural communities at the moment. I've just gotten to know Chief Suckling in the past few months, and I will tell you, he's a passionate advocate for getting people into treatment. His department is leading the way for sure. So just to share a little bit of his testimony, my name is David Suckling. I'm police chief in Alexandria, representing the police chiefs in support of the bill. I would like to shed some light on a grave issue that has been haunting our communities here in New Hampshire, the exposure of our children to illicit fentanyl. He goes on to say, in recent years, New Hampshire has seen a heartbreaking rise in drug-related incidents. Among these, the dangers presented by fentanyl, a synthetic opioid that is 50 to 100 times more potent than morphine, are particularly alarming. This substance is not just a concern for adults, but it poses an ever-growing threat to our children. He goes on to talk about the example that Tess gave that changed his career with the family, where their child, age 1, ingested fentanyl and passed away. And now 1 child is dead and 3 adults are sitting in prison. He goes on to say we must acknowledge the bitter truth. Fentanyl is not a distant issue. It's our issue. It's in our neighborhoods, in the home of our loved ones. As illicit drug markets continue to proliferate, counterfeit pills laced with fentanyl are increasingly being sold, misleading unsuspecting users. And then I'll go to some of his remarks at the end of his testimony. As we contemplate solutions, we must prioritize legislation that protects our children from these preventable tragedies. There is an urgent need for laws that regulate the distribution of fentanyl and mandates safe storage practices for medications. He goes on to talk about education, education of families, and then in closing, asking that you would find this bill ought to pass.
I may inquire about one question.
Sure.
Although I agree with 99.9% of this, the effective date is January 1st, 2026. What is the harm of making it effective upon passage?
Yeah, we would agree 100%.
See any questions? Seeing no questions, thank you for your testimony.
I'd like to make a motion to go into executive session.
What?
Oh, you didn't close the hearing yet.
Are there any members of the public who wish to testify in regards to HB 473 that are here that wish to testify aren't here already? Dr.
I
Hannon.
almost cut him off.
I'm ready, thank you. All right. Mr. Chairman, members of the committee, thank you for the opportunity to testify today. I'm here to respectfully urge you to vote no on HB 473. This bill expands criminal penalties for exposing children to controlled substances and gives law enforcement the power to forcibly remove children from their homes and place them in protective custody based on mere suspicion of drug exposure, without a warrant, medical evidence, or proof of harm. On its surface, the intent of this bill is to protect children, but in practice it may do the exact opposite, causing lasting harm, tearing families apart, and undermining both civil liberties and evidence-based child welfare practices. Removal is traumatic and harmful to children. The evidence is clear. Removing children from their parents causes psychological harm. According to the National Institutes of Health, removal, especially sudden or without explanation, can result in chronic anxiety, attachment disorders, and long-term emotional distress. The University of Washington found that mothers who lost custody of a child due to substance use were twice as likely to have a subsequent child removed, creating a vicious cycle that compounds trauma for children and deepens despair for parents. Substance use does not necessarily equal abuse or neglect. This conflates parental substance use with child abuse, when in reality, the vast majority of parents struggling with addiction love their children and want to keep them safe. A study from 0 to 3 emphasizes that substance use alone does not constitute maltreatment, and removal based on exposure rather than actual harm can be misguided and deeply damaging. According to Casey Family Programs, children fare best when systems prioritize family preservation and not punishment. This bill invites overreach and disproportionate harm. The language in this bill uses phrases like reason to believe or presence of a substance. It's vague and highly subjective. It opens the door for arbitrary enforcement and racial or economic bias. We know from the Urban Institute research that Black, Indigenous, and low-income families are already overrepresented in child removals linked to drug allegations. Once a child is removed, data shows that they are more likely to spend longer in foster care, face adoption over reunification, and endure instability in placement, especially if their parents are poor or in early recovery. It violates civil rights and medical ethics. It enables police to seize children without judicial review and authorizes involuntary medical screening, possibly without parental consent. And that raises serious concerns under the Fourth Amendment, unreasonable searches and seizures, and the 14th Amendment, due process, equating it also with parental rights. The Supreme Court, the U.S. Supreme Court has repeatedly affirmed that parents have fundamental liberty interest in the care and custody of their children. That's Troxel v. Granville, 2000. Bypassing due process, this bill places the state between the parent and child, which is sometimes necessary, but this is without adequate checks. There's a better way. We all want children to be safe, but safety does not come from punishment. It comes from support. Recovery is more successful when parents remain connected to their children. Programs like family-based treatment, trauma-informed care, and harm reduction keep children safe while helping parents heal. Instead of criminalizing vulnerable families and their children, we should remove barriers to treatment, housing, and supportive services that address the root causes of substance use and instability. So in conclusion, though it's well-meaning, it has dangerous unintended consequences. It risks harming the very children it aims to protect, and it criminalizes families in crisis rather than helping them recover. I've urged you to vote no on this bill and instead champion legislation that reflects compassion, evidence, and constitutional principles. Thank you very much for your time, and I'd be happy to take any questions.
If you don't mind, I think I cut you off, but can you state your name for the record? I think I said your name, and then you didn't say it.
I thought you saying it was better, but yeah, Joe
I
Hammond.
thought so too, but
Yeah.
apparently I was notified by the corner over here, not acceptable.
It's my fault. Don't blame him.
All right,
Yeah,
and did you testify and voice your opposition in the House?
I did not. And because this bill kind of slipped through my radar because I try to read every single bill, whether it relates to something I'm speaking with him on or not, just to see if it's in there. And there were a couple bills. I'll admit 3 bills slipped through the cracks for me this year, and I'm trying to correct the problem in the other chamber. I get the bill, though. I mean, I understand the motivation, the people wanting it, the enthusiasm. I get it. It makes sense from an emotional level, but from a fact-based scientific level that has decades and decades of research about children and separating them and the effect that it has on people in recovery or pre-recovery. And even if they're not in recovery, it has nothing to do with substance use. Just removing children has a profound impact on children that can cause an incredible amount of negative consequences. So, yeah, sorry.
Thank you, Mr. Chairman. Thank you for your testimony. Just to be clear, your testimony, the unintended consequences that you spoke about related to the harm of the person with substance use disorder.
And children. I was specifically talking about the harm to the children, which is why we're here, I believe. It does cause harm to the parents and the person involved, and I understand the lack of sympathy sometimes for people who are using substances, but like I said, substance use does not mean abuse, and this is a blanket carte blanche for law enforcement to just take someone's children from mere suspicion, and I understand the concept, but it's ignoring all of the other possible negative consequences. I'm a father. I have 2 children. My youngest is 16 years old with Down syndrome, and we recently found out has autism. She's extremely sensitive to touch, sounds, noises, all kinds of things. I mean, we can't even get her blood drawn very easily. We have to go to a specialist in Boston for one person. It's still a very traumatic event. She might not be talking for a week or 2 afterwards just because the trauma of going to get her blood drawn. Now, someone was going to come in and say, if it's not my daughter, it's someone else's, and so a similar child could be irreparably harmed just from removing them temporarily due to a mere suspicion. And I don't think that meets the threshold of legal necessity to take a child away, knowing that those other factors are so serious and potentially harmful. Long-term effects, it can affect not just neurodevelopment, it can affect other health problems. There's a vast cascade of stress hormones that are released that can affect anxiety, depression. It can cause diabetes, heart disease. There's so many things it can cause later in life, and substance use. And also people that are removed, foster care system is more harmful to children than even leaving them with parents who are maybe not perfectly adapted to taking care of them, but are doing their best.
Oh, okay. So I'm looking at this bill as exposing children to controlled substances, screening and testing. So if the screening and testing shows that the child's not exposed, no harm done?
Like I said, they've just taken a child, someone say like my daughter, and they've performed an invasive medical procedure against her will. So forget about the will of the parents and their permission. The child is an innocent person who is now being grabbed, taken away against their will, against the parents' will most likely, and then maybe put a needle into their arm or some other trauma. And like I said, that has lasting effects. I've seen it personally on my daughter, just getting blood drawn, just for routine medical checkups. We don't do it every year because it's so traumatic. So we do other things to do that. Luckily, our parents are both doctors, so we can figure stuff out without it doing every year. But we need to realize that there are a lot of children out there that have horrible effects. I've worked in the substance use field for many years with different organizations, and one in particular I worked with has worked with hundreds and hundreds of children and their parents, and the goal is to reunify them. And we've seen time and again that children that are reunified with their parents, not only the parents do better in recovery, but the children do better. They're less likely to be in the system. Once a child goes into the system, once a parent loses a child to substance use to the system, they're much more likely to lose a second child, and those children are more likely to stay in the system and increase criminal behavior, substance use, and other health problems later in life. So the ultimate goal is obviously to preserve it as much as possible. We do have to have safeguards in place, but there is no reason that if a police officer finds something that's that dangerous or potentially harmful, that they can't get a warrant like any other crime.
Follow-up for me? Yeah, so actually you were the one that persuaded me, I don't know how many years ago, 8 years ago, with respect to harm reduction, so I know your expertise in that well.
Thank you.
So again, police aren't randomly pulling people because I think they have to have probable cause, I would assume.
I understand.
If it's the probable cause that they're talking to a parent and there's cocaine or any substance sitting on a table with a 3-year-old walking around wildly, that would be probable cause. So I mean, I'm looking at from Manchester's side. I hear too often of children that have been, children that have been in the presence of substances that feared them and there was nothing they could do. And oftentimes those kids are affected by that drug, whether it's through the skin, whether they're copying their father and snorting it, or
Absolutely.
they believe they're shooting it up or whatever. So I know there's a delicate line between the adverse effects it'll have on removing the children. The bottom line, by removing the children, if the screening shows no issue, then the children are back. If the screening shows that there is an issue, then I think that's better for the child that it was caught instead of waiting until something randomly happens worse to the child. So that's it's not really a struggle with me. The fact that it's exposing children to a controlled substance, if that's the case, then I would be opposed to that.
Opposed to, I'm sorry?
I would be opposed to looking at the detrimental, the detrimental things that happen with a child being pulled from its parent.
I understand,
The
sir.
fact that it's protected by the exposing of a controlled substance is my first factor of consideration.
Senator Sullivan.
Thank you, Mr. Chairman. Honorable Joe Hannon. I find myself in an unusual situation of being on the opposite side of an issue of you. So my concern, and I echo a lot of what Senator Long said, but you said there's a profound impact on children if they're removed from their parents' custody. Granted, but in a lot of these cases, there's already a profound impact on these children because they're living in a home with people that are living in addiction. And I think I would disagree with you that there's that's a safe place for them to be often, and it's not neglectful, because when someone is actively using, they can't take care of themselves, never mind their children. So I would ask you though, because this is your expertise, seeing this, what about this would you support, or what would you have changed to protect children, but also address your concerns?
I'd remove the arbitrary ability of police to remove children without a warrant. It's not hard to get. It takes how long to get a warrant? A few minutes, half an hour tops. They can stand and wait while they're getting the warrant if that's the case. So if there's truly a danger, I think there needs to be judicial oversight. You can't have somebody who is obviously biased against people who use substances and thinks that everybody who does them belongs behind bars. That's actually harmful to children. And like both the senators on the ends here were saying, there are a lot of other things. They're weighing this against the harm of potential exposure, but the evidence is quite clear. I'll give you a bunch of studies. I'll give them to you right after this if you'd like, that have been saying for decades that it's actually more harmful, even in households that are not ideal. No family's perfect. I know tons of families that don't have substance use issues that I wouldn't want to be in. But I also know how I'd feel if somebody came into this room, and imagine any one of us in this room was sitting here right now, an innocent person, and people came in and argued with your mom and dad who happened to be sitting behind you. It's kind of weird, and they just grabbed you and took you out and start sticking needles in your arm, and you're 3, 5, 6 years old. How would you feel? Think about the harm that's going to cause. Now, we're adults. We could probably rationalize, well, I have nothing to fear. Who cares if they take my blood or stick a needle in my arm? But we're talking about children. That does have a profound impact. Now, there are cases of exposure that are dangerous, and I don't think that they should be left unchallenged, and they need to be addressed, but that can be done through the courts. It can be easily done with a warrant. It does not need to be arbitrary. It does not need to be biased. It does not need to be as traumatic for children. We're here to protect children. That's what this committee's for. Obviously, I don't need to tell you. You've been doing this more than me. But I've seen firsthand. I've read the research, and I have yet to see any research that says it's more helpful to remove the children. There's anecdotal evidence of, one child died of an overdose. It's horrible. But that does not overlook all of the other potential harms. So instead of finding a few things, and the numbers have gone up, I agree. They've gone up hundreds of percent, even I think 3,500 or more percent. Some of these overdose have gone up specifically for fentanyl, for in those years that were talked about earlier that another speaker, I forget who it was, said. But when you talk about hundreds or thousands of percent increase, you have to look at what was the original number. The original number of fentanyl overdoses for children under the age of 6 was 10 in a year. That's a horrible number, but it was 10. So when it goes up to 120, it's a 12 times, it's 100, it's way higher. We're not talking about tens of thousands of people, but we do have 100,000 people a year dying of overdoses, mostly adults. Children do get affected, but the true trauma takes years and decades to really be apparent. Just because you don't see it today or tomorrow does not mean it's not as dangerous or more harmful to children. Childhood trauma lasts for a lifetime in many people, unfortunately, especially without help. And when they go into the foster system or they're removed from their parents, they're less likely to get help. Children in the foster system are less likely to get immunizations. They're less likely to get their health conditions looked at. I can give you statistics on those. It's like 32% of children in foster care aren't getting a health condition taken care of or even looked at. And there's tons of data that shows that they're more likely to be human trafficked, to be victims of sexual abuse, to be criminals themselves and have substance abuse issues if they're in that system. It's a necessary system, but we have to do as much as we can to prevent that from happening and keep families together as much as possible. And when they can't be, the court should intervene.
So if I could ask you a question. I understand what you're saying. There's concerns about, you've expressed concerns about police perhaps overreaching or abusing the authority that they may have. But from what I understand, that concern would be with the existing law as it applies to methamphetamine. And what I'm looking at is, I think the biggest drug issue facing our state is really fentanyl. And this is just applying it, I think, to any controlled drug. So perhaps we don't have to keep revisiting this every time we have a new drug problem in the state. So I guess my concern is perhaps the procedure and the process of which this would be enforced may be your objection, but the existing law would have that same problem. So even if we didn't pass this, your concerns would still exist under the law. So I think major policy change as you're suggesting, perhaps, do you think we should revisit that at a different time? And why not expand it to all controlled drugs, especially with fentanyl?
I mean, if you'd like to add fentanyl, it's your prerogative, but if you'd like to remove methamphetamines at this point, that would solve the problem also in that sense, because there is a way to do this without having that arbitrary power given to law enforcement officers. You know, on page 2 of the bill, line 3, one of the things that is banned is storing any chemical substance. You know, and that's just one vagary that I've found in, you know, page, I'm just turning it over for real quick perusal. Chemical substance doesn't say illicit substance, doesn't say illegal substance, it says chemical substance. So if you pass it, you could theoretically take someone's children because they have water or table salt, which are chemical substances. So I think this bill is, you know, if you think it's that well intended, I think you need to study it more and bring in advocates for both sides of the issue, not just law enforcement. I think that, you know, you need to bring in people from all the areas that deal with this. I know people that deal with women and children in recovery, pre and post treatment, and I think that they need to be brought in.
But isn't that the existing law again? That's
To what?
unchanged. That's, that reference you made, storing any chemical substance. That is the,
Yeah,
and, you know, I think, from what I understand, there's a lot of chemical substances used for
there are,
cutting agents, so
right?
I can imagine that's why that was put in there, but I'm saying is not passing this bill doesn't address that concern either. So what I'm wondering is, what's the objection to really expanding this to cover fentanyl and opioids?
Well, you've already pointed out that the bill as it, the law as it currently stands has some problems, like I was pointing out. But to expand it would only make it worse. So, you know, I don't know what else to say.
Thank you. Any questions? Seeing no questions, thank you for your testimony. Are there any members of the public who wish to testify in regards to HB 473 that have not testified already? Seeing none, we'll now close the public hearing on HB 473.
I'd like to make a motion to go into executive session.
Second?
All in favor?
Aye.
Aye.
Aye. All opposed? We are now in executive session.
I'd like to make a motion of ought to pass on House Bill 473.
Second?
Any discussion on the motion?
I support the bill. I take into consideration Honorable Joe Handon's remarks. But I think that we're in a situation where we can't wait to do this. And that a lot of the people that will be touched by this are already known to the police. They're following these families and, you know, waiting. If you see something and then waiting to get a warrant, it takes only that amount of time for a child to get into a substance and not be with us any longer. And I think the numbers of the increase in deaths we're seeing are just unacceptable, and we need to do something.
I think the points raised by the Honorable Dr. Hannon are well taken. However, I understand the concerns about government overreach, but we didn't hear any examples of that actually happening. So I think credit to law enforcement with the existing law.
Mm-hmm.
You know, if that was a problem with the, you know, presented to us, I think we would have to examine that. And it probably would have already been examined in prior bills. So without hearing any, you know, what could happen as opposed to what's actually happening in the real world, you know, we'll obviously keep an eye on it, but I don't see any reason why we don't expand it.
And as far as drug testing too, it's usually urinalysis versus a blood test. Right. So, I mean, there are ways to test that aren't that invasive. But the reality is, the way I see this, and you know, I work with this community a lot, people that are in recovery or currently in addiction. I see this as an opportunity to help the parents that are in that situation and while also helping the kids, because it takes drastic things to happen to you sometimes before you actually take the change to seek recovery or to make recovery stick. So I see this as an opportunity to actually help these families.
Yeah, I don't want to get into examples of people I know who've gone through this, whether it was friends, clients, whatever, but it's a tough situation when there's children around. And I've worked on cases where custody became an issue because of substance abuse, and it is complicated, but there is a process for it. So I think we'll trust the process and keep an eye on this. And obviously, I think I think expanding the policies is better for public safety, so especially for kids. So, move the question. So all those in favor of ought to pass, say aye.
Aye.
Aye. All opposed? The ayes have it. A motion for consent, anyone?
So move.
So moved.
All in favor?
Aye.
All opposed?
Wait.
Oh, aye.
I'll take it.
You want to take it out?
I'll take it out.
There's a fight for that one. All right, so 473 is on consent. And motion to come out of executive session?
So moved.
Second.
All in favor?
Aye.
Aye.
All opposed? The ayes have it. We're now out of executive session. At this time, we'll now open the public hearing on HB 560. Introduce the bill. We have Representative Litchfield. I should have known when you stood up. I think I need another cup of coffee, but I'm stuck in here.
I think you do too. You said he was under yourself.
My aide's in here too.
Your Pepsi.
She only brought water for herself, huh?
One way. I do have to say, actually, thank you, because this is the third bill I'm testifying on in 1 week with the Senate. And Senator Sullivan, you've actually been a member of each of 3 completely different committees. So thank you for the commitment that you all have to the state of New Hampshire. Seriously, you're very busy people. Just her, no.
All right.
Well, Senator Abbas, it goes without saying, yeah. So, hello, Chair Abbas and fellow members of the committee. My name is Representative Melissa Litchfield. I represent the towns of Brentwood, Danville, and Fremont. This particular bill is just relative to parental access to a minor child's medical records. I personally feel that it's overdue at this point in time. Parents do have access to their child's records if they were to go in person, but if they were to try to access the records online, they do not have access between the ages of 13 and 18 with most portals. One of the concerns that I have is just simply the fact that parents are directed to the portal, whether it's convenience, for whatever reason, the medical practices are trying to streamline things, but they're saying to the parents, please go to the portal to whether it be schedule an appointment, get refills, or even to pay the medical bills. So the parents are on the line, they're on the hook, they have to cover the bills, etc., but yet they don't have access because once the child turns 13, they actually turn off parental permission and they say that the child has to have their own email. One of the other concerns with that is many children do not have their own email outside of, let's say, a school email. And I don't know, I know me personally, I don't know what my comfort is with the school or any outside organization having access to your child's private medical records. Some of the pushback that we've have received is simply the fact that there are some state and there are some federal laws where there is information that would be redacted that the child, or excuse me, the parents would not have access to. And that is, for example, certain testing for STDs, for example, birth control, etc. There are laws out there to protect the children and the population at large. I believe the argument is simply that maybe these teens would not seek help if the parents were involved.
probably a discussion for another day. But regarding the medical records, I'm just simply asking that we continue to make New Hampshire a place where parental rights and involvement are a priority. I have concerns right now that we are prioritizing the physician-child relationship over the parent-child relationship. And I know some of the pushback that we received is just simply organizations are saying, look, it's going to be tedious for us to redact information electronically when it comes to whether it be therapy or it comes to the STDs or birth control where the parents aren't supposed to have access to this information. To be perfectly blunt, that's not our problem. You need to figure it out, and we need to make parents be a part of the picture. So, thank you.
Thank you, Representative. Any questions? Okay, Senator Long?
Thank you, Madam Chair. Are you familiar with a proposed amendment? I'm not sure.
not.
You know, I got 3 copies. I don't know if I was supposed to pass them out to you. Do you have one?
Are you not sharing today? Senator?
Yeah, well, I noticed I had 3, and I'm wondering, oh, that's what it is. Okay, that's fine, thank you. It's not a, okay.
Representative, do you know where the amendment came from, the proposed amendment?
I don't. Yeah, actually, it came from, what was her name? Okay.
Thank you. Any other questions, Representative? Thank you, Representative.
Thank you.
Jay Makis? Did I say that right? Jay? No. Melissa Blazik?
Hello. Thank you, Madam Chair, members of the committee. I'm Melissa Blasick. I'm here representing Rebuild NH. I'm here to testify in support of HB 560, a bill that simply and clearly affirms a parent's right to access their child's medical records, both physical and electronic. Under current federal law, parents have the right to request and receive their child's physical medical records. However, there's a glaring and growing gap when it comes to electronic medical records. Many medical practices in New Hampshire and across the country automatically cut off parental access to a child's patient portal when the child turns 12 years old. That means parents lose access to immunization records, appointment scheduling, lab results, and basic health updates, not just sensitive information. This has become one of the top concerns I hear from parents. They're locked out of their child's care simply because a system default treats all information the same, regardless of its content or the actual intent of the law. Both federal and state law protect a minor's privacy when it comes to specific services such as STD treatment, substance abuse treatment, and birth control. And in these cases, where a parent requests physical records, that information is redacted. Medical practices already know how to comply with these laws by redacting the necessary parts. But instead of applying the same approach to medical records, many providers are taking the broadest, most restrictive option and cutting off all parental access. That's not compliance, that's overcorrection. And let's be honest, a 12-year-old, they are not developmentally capable of independently managing their health care or navigating complex medical systems. They can't schedule appointments, understand test results, or ensure follow-up care is completed. Expecting a child that age to manage their own records and medical decisions while excluding the parent is not just unrealistic, it's irresponsible. HB 560 doesn't ask providers to do anything new or radical. It simply says treat electronic records the same way that they currently treat physical records. Give parents the access they are legally and morally entitled to, and redact only what the law requires. HB 560 restores balance, clarity, and common sense to a system that has lost sight of critical role that parents play in their child's health care. I urge you to support this bill.
Thank you. Any questions from the committee? Seeing none, thank you.
Thank you.
Ben Bradley?
Good morning, Senators. Still morning. For the record, my name is Ben Bradley. I work for the New Hampshire Hospital Association. We represent all 26 of the state's acute care hospitals as well as all specialty hospitals. Thanks for the opportunity to provide some insight and share some of our concerns with this bill. I do want to state that we completely agree with the general statement of purpose for this bill, which is that the vast majority of parents absolutely are acting in their child's best interest. They have access to their child's medical record, both physically and electronically, and I'm happy to go through the difference between physical, electronic, and what the patient portal is, and are responsible for providing access to and coordinating medical care. However, this bill as written raises some concerns for our members, which is why we support an amendment to resolve those concerns. That amendment is what you've cited, and I've also included a copy in your packet. Of particular concern is, starting on line 9 in the bill as passed in the House, the inclusions of the words, including records available via online patient portals. To define a medical record this way creates a technology standard that currently cannot be met by many hospitals in the state and their electronic medical records. That's because patient portals should not be considered as part of the definition of medical records in statute. This bill acknowledges in Section 2A that there are records protected under federal and state laws that parents are not able to see without their child's consent, such as substance abuse treatment, sexually transmitted disease treatment, reproductive health services, and emancipated minors. Technology limitations of many of the hospital's patient portal systems are not capable of nuanced parsing of the medical record to redact these protected services in the patient portal. They would do it in an electronic medical record where they could send a copy of the medical record redacted with those protected services. But the patient portal in some of the electronic medical records is not able to parse out those nuances. There is a concern that if this bill passes, those entities may have to just turn off the adolescent's portal in order to comply with what the law is doing here. Additionally, the protective orders clause in Section 2B raises questions about implementation and puts healthcare providers in a position to interpret complex legal documents and postures of the court. Our members can only act on information provided to them by a patient, parent, or legal guardian. On the preliminary protective order portion of this bill, those orders can be issued without advance notice to another party, while the subject of the protective order is entitled to a hearing to challenge the allegations. That can be days after an initial order. So the question is, one of the questions we have is the initial order sufficient to trigger this law and withhold access to a medical record, or is it after a contested hearing? Protective orders also expire. What happens if an order expires but nobody tells the healthcare provider a situation likely to occur? How would providers know when the case is resolved and therefore the order is no longer valid? What about sentencing orders that have no contact orders as a condition of probation or parole, or a suspended sentence? Those only last while the person is on probation or parole for the suspension period. There is typically no paperwork that firmly says a case is resolved and the bail conditions or probation conditions are lifted. What would be sufficient documentation for hospitals to lift the denial of access? Taking the above into consideration, if the protective order is no longer valid, but nobody tells the healthcare provider and the hospital denies access to a patient or a parent, the hospital would be in violation of federal information blocking rules, which are separate from the state statute. The proposed language puts the healthcare provider and hospitals in an untenable position of having to essentially do a deep dive into court orders and protective orders. And as noted before, these folks who are getting these requests can only act on official information that has been presented to them at the time of a medical records request. Therefore, our amendment attempts to make changes to help resolve those concerns. Given these concerns, we're not able to support the bill as passed by the House, but support an amendment to resolve these concerns to ensure parents are given access to their children's medical records as they should. I welcome the opportunity to work with you on this important topic, and I'm happy to take any questions.
Senator Sullivan.
Thank you, Mr. Chair. Thank you for taking my question. Did you present this amendment, or proposed amendment to the House?
We did not. I think that it has been tossed around a little bit with some House members that share our concern around patient portals and the concern about if this was to move forward without a capability to parse out the child's rights, if you will, versus the parent's access. You know, they want their constituents to still have access to a patient portal. And so just having that distinction, I think, will be important, as well as some of the other things I've said. But to your question, it is something we've been trying to work on and not outright object to some form of legislation that passes. So working in good faith.
Follow up. In regard to your testimony about the parent or guardian reasonably believes the in professional judgment, the individual subject to domestic violence, abuse, or neglect, doctors are mandated reporters, are they not? So
Yeah,
if they
they are.
had that, so that doesn't actually need to be in the amendment because that's already part of what's necessary in their job.
So, Senator, I think it's a good question. The point I would make is there's a difference between making a medical records request and reporting of the child abuse and neglect. So providers have a duty to report on child abuse or neglect, just as everybody does, as you know. This language really speaks to the parent's access to a child's medical record. So when the reason we've made adjustments to the language as written out of the House is to try to align with federal regulations as they already exist today. So, for example, as it's written, the bill states when a healthcare provider has determined by evidence based on articulable facts, right? That's different than the federal regulation, which says that the provider, using their professional judgment, reasonably believes that there may be child abuse or neglect. So we want to make sure that's aligned because the providers who are seeing these children and anybody who's issuing a medical record, we don't want one standard to be one thing and another to be another and having to figure out whether they should withhold the medical record or not.
Thank you.
Senator Long.
Thank you, Mr. Chairman. So just for clarification, my understanding is what you testified to is the patient portal. You cannot deduct from the portal some information that you would like to deduct. So you would like to scratch the language, including records available via online patient portal?
Yes, and if I may just share a little bit more on that. Patient portals are a wonderful tool for patients and caregivers and others. They are a way to make appointments, parents making appointments, and the like. And there are other ways to make appointments outside of just the patient portal, right? The problem when you try to afford access for a parent to have access to medical records in a patient portal is those patient portals don't have the technological capability in some cases to parse out or distinguish the parent accessing the child's portal versus the child accessing the parent's portal. And therefore, you'd be in violation of the existing protections for the child. I would say that if a child says, hey, Mom, I really want you to have my login information and take care of this for me, they can do that. That's on their own will. But as a provider and trying to stay in compliance with the law, we want to make sure that that information is protected and we follow, the confidentiality that they entrust in us until they may release it themselves to the parent.
Okay, follow if I may. Now, the electronic medical records, are there more on the portal? Or the fact that they're getting electronic medical records, would that be pretty much all the records physical and electronically?
So what would happen is if you request a medical record electronically, the parent could make that request of their minor, but certain elements of that medical record would be redacted in the electronic medical record that's being sent via email or the file being sent electronically. That's different than having patient portal access and clicking through tabs or dates or appointments. And so I wish that we had the technological capability, and I think eventually we may get there. But as it stands right now, my concern, our members' concern is, we like being able to provide adolescents their portal access so they can see, their medical information, their records, whatever it may be. But if this moves forward, we'd have to be in compliance, and we're going to do everything we are required to do to be in compliance, which may mean that those adolescent patient portals would have to be, taken down. And they'd have to find other ways to interface with their medical care.
Right. Follow up if I may?
Yes.
On C is staying with federal codes. See the added of the language and
Yes, sir.
deletion?
Yes, and I would just, I included just briefly, if I may, in your, in the materials I gave you,
Yeah.
this packet from the Adolescent and Young Adult Health National Resource Center. They did a review on New Hampshire statutes, but also included in there on page 16, I'm going to point to the reference for you, is the start of reference to 45 CFR section 160.502. That's on page 16 of that packet that I just handed out. If you flip to the next page, 17, where it carries over that section, number 5 talks about abuse, neglect situations, and when we may have reason to believe in a provider's professional judgment that it's not in the best interest of the individual to do that for reason to believe of child abuse and neglect. So we can, that's cited there.
Good, thank you, Mr. Chairman.
If I could ask you a question, if you don't mind. So,
Certainly.
let's just say this was passed as it's written and became law. In regards to that, the abuse protective orders involving children.
Yes.
Assuming you knew about, if the hospital knows about it, that's one thing. But let's say they didn't know about the order, and those records were requested, and they were then provided through a HIPAA form was provided. They were provided.
Right.
What would the consequence be to the hospital from like a remedy perspective?
So we are acting on the information that we're provided. So if no information is provided to us on that front, and we issue that medical record, not knowing there was a protective order, there's nothing we could have done to know. So I don't think there would be a violation or a penalty because we're acting on the information we have.
So I suppose if you knew about the order and just disregarded it, that's
Certainly.
different. But so
Certainly.
So I certainly understand the concern of not wanting to disclose the records to someone who isn't entitled to them or legally
Correct.
allowed to get them. But
Correct.
if it's done, without the knowledge of the order, I guess what is the objection to that provision? Because if there's no consequence to the medical.
Right, so you're speaking to section B, is that right?
Yes.
Okay, so just for a little bit of clarity there, section B reads, when the parent or legal guardian is the subject of a protective order involving the minor child or one of the minor's child's siblings issued pursuant to several citations in state law. The concern there is that the protective order doesn't specify that the parent doesn't have access to a medical record, right? So a protective order is to say you can't be in proximity to the child, you can't be, making, forcing them against their will or whatever it may be as a protective order, but there's no specification for medical record. So when somebody who gets a request for a medical record sees that a protective order is coming to them, they can't act on that protective order unless it specifies that the medical record is not something that can be issued, which tends not to be outlined in a protective order, right? So that's why you still have the second part of Section B, which says, when a court of competent jurisdiction has determined that the release of the records to a parent or legal guardian is not in the child's best interest. So when it is specified by a legal, by a court of competent jurisdiction, then we would say, of course, we're not gonna disclose that. But how do we make a judgment on a protective order is the question.
But wouldn't you not have to make that judgment if there's a protective order, it involves the parent and it involves the child, it's just a matter of fact. That's it. They don't have access. So you're not interpreting the order, it's just whether the order exists. Am I correct?
Well, I suppose if that's what you want the policy to be, if you want the state policy to be that under a protective order you wouldn't have access to a medical record, that's one thing. But otherwise,
Sorry, Ben, can you join me?
sure.
If I can.
Otherwise, the protective order does not specify access to a medical record.
Hi, for the record, Senior Director of Government Relations at Dartmouth Health, Courtney Tanner. Senator Abish, you are exactly correct. And I think that the intent of the language is strong, as Ben is trying to point out. This is just a little bit of cleanup with this amendment, because what happens if there's a protective order from Massachusetts? And so striking the references to the state statute just makes it so that if there's a protective order from a different jurisdiction, that's also contemplated within the New Hampshire statute. I just want to underscore, Dartmouth Health, I can't speak for all hospitals, but Dartmouth Health supports the intent of House Bill 560. We champion parental access to medical records. We champion parental involvement in care. I've told you, Senator Sullivan, I have a little child with an esophageal disorder. She's going to need my help until, trust me, my husband has the same disorder. He still needs my help. We very much want to ensure that parents are intimately involved in their children's care. Just wanting to make sure that it just strengthens it so that we can make sure we can effectively implement it.
So I understand correctly, as it's written, it only would apply to abuse prevention order in the state issued by the state of New Hampshire, where it should apply. So it really should apply to, it can be if it's issued in any state.
Absolutely. Yep, so it's just a cleanup for B.
And I asked a question earlier about if the hospital's not aware of the order, through no fault of their own, no one told them that, it is what it is.
Unfortunate, yeah.
Someone requests it who's not supposed to get them because they're part of the order.
Sure.
Then what is the legal consequence to the hospital in that scenario?
Well, I imagine if we didn't know about the order, there would be no liability. We would hope that an order would be communicated, whether that's an order that DCYF is holding or the protected party, that's communicated to their healthcare provider.
And just a general question. So there's a lot of different medical institutions.
Sure.
So it's one thing if one hospital, one facility gets it, but are they able to then see throughout the records that if they were to?
It depends. So at Dartmouth Health, we have an integrated medical record. So if you access care up in Lebanon and then you access care down in Manchester, we actually do have an integrated system within our system. And I can only speak to.
Right. So if you were hoping that, maybe Dartmouth got the record, Dartmouth got the protective order, but another entity did not, there may not be that communication to know. So again, the folks who are issuing medical records are doing their best to identify and stay in compliance, but if they're not provided information, then, they can't act upon it. Things they don't know.
Thank you.
Thank you, Senators.
Seeing no questions, thank you for your testimony.
Thanks.
Is Dr. Sandolo available?
Good morning, Mr. Chairman and members of the committee. Thank you for this opportunity to testify. My name is Aida Cherundolo, and I support HB 560. I am a board-certified emergency medicine physician with over 20 years of experience treating children and adults, but more importantly, I am a mother. I support HB 560 because parents need access to their children's medical records in order to best support their health and well-being. I was cut off from my children's medical records when they turned 12, and it impeded my ability to best help my daughter recover from an injury that required care of a specialist. I could not view any information regarding her visits, including her documented diagnosis and treatment plan. I tried 3 times to access my children's records at 2 different offices, but I was unsuccessful. I finally called the IT department to find out why, and I was told I was given the wrong form to complete. I was given the wrong form 3 times. Hospitals haven't reconciled the issues of selectively shielding parts of the record, so as a result, parents are left jumping through hoops. New Hampshire law recognizes that minors are different from adults. Minors are considered to lack capacity to enter into legal contracts, for example. It is nonsensical, therefore, to declare that children universally have capacity to make independent decisions regarding their own health. Minors cannot consent to the transfer of their own records, and they cannot consent to invasive procedures. Yet parents are expected to provide consent for record transfer without access to the records themselves, and consent for procedures without the electronic access of the health record detailing why the procedure is necessary. The potential for medical error is increased without parental oversight to confirm that the health record is accurate. A Johns Hopkins study suggests medical error is the 3rd leading cause of death in the U.S. Medical history and medication allergies, for example, are important pieces of information that help clinicians make safe decisions. In the cases of concern for harm to a child necessitating shielding the record, documentation of this concern should be followed up with a report of suspected abuse to DCYF. Healthcare providers are mandated reporters of abuse, and suspicion alone is enough to warrant a report. A difference of opinion between the clinician and the parent should not be enough reason to shield the record, and if DCYF finds no concerns, the record should then be reopened. Shielding the medical record from fit parents demotes them to bystanders while the clinician becomes the proxy parent. But a child with loving parents doesn't need a proxy parent. Please support HB 560. Thank you, and I'm very happy to answer any questions.
Seeing no questions, thank you for your testimony. Are there any members of the public who wish to speak?
Thank you, Mr. Chairman. And this is on House Bill 560?
Yes, it is.
Okay, thank you. Thank you for allowing me to testify. My name is Jay Markell. I'm a state rep from Rockingham District 18. I'd like to speak in support of this bill. First, the rights that are stating here actually do exist in a number of different areas, and it's part of substantive due process where parents have a fundamental liberty interest in raising their own children, which also considers medical care. This bill makes it more specific, and a couple of points that I might be able to testify on. Number one is that these rights actually exist, and people who are either divorcing and who have minor children have to fill out a parenting plan pursuant to RSA 461A. That parenting plan, which is available online, I should have brought one in on page 7, indicate what rights the parents have. And the rights is to access medical records, educational records, and so on and so forth. So if a hospital, this bill might be necessary to be able to put hospitals and other people on notice as to exactly what parental rights are. They do include the right to access medical records, and it seems unfair that somebody who is either filing a parenting petition and gets these rights as a matter of law, because every parenting petition, which means unmarried parents or divorcing parents, will get these rights because under the law, parenting rights and responsibilities under 461A require a parenting plan to be able to complete that. So it seems to be inconsistent to have one set of rights for people who are going to go to court and they get them as a matter of law, and to have people who have intact families not be able to secure these rights, either because the medical providers either are not fully up to speed on the law, or it creates needless barriers. And by the way, even people where you have sole decision-making, where the presumption is joint decision-making, does not preclude the parent who does not have the decision-making capabilities, doesn't preclude access to the children's records. So under that set of circumstances, this bill would obviously be necessary if people are being denied access to the records, which leads us to a couple of other things here. What we're talking about here is basic medical records. Now, one of the lead cases in the state of New Hampshire is In re Berg, and you'll probably hear people in the child and family law community refer to this quite often. It's a lead case from 2005, which holds that children have rights to privilege under medical privilege laws, like psychiatric or therapist-patient privilege. And it would be up to a court to act in the best interests of the child to be able to withhold or order those records unavailable or make them available depending on the facts and circumstances. That's a decision which I support, because even though children do not have the full panoply of rights as we do under the law, nevertheless they do have some expectation of privacy in patient-therapist privilege. So I think the New Hampshire Supreme Court certainly got that one right. Courts generally apply it. So as to the rest of, and by the way, just to follow up and show you how confusing things really can be, courts, if there is a guardian ad litem on a case, okay, and if it's really necessary, a guardian ad litem can apply to a court and get a waiver of privilege, okay, if it's absolutely necessary for some reason. As to the other aspects of the statute, when we're talking about lines 12, for example, when records are records of treatment that a minor may consent to pursuant to a specific statute under state or federal law without parental consent or the consent of a legal guardian. Now, generally what this refers to are things like whether a child at 14 years of age or older or whatever may consent to test for sexually transmitted disease and have that shielded from the parents. One of the other ones is whether or not a child can get a judicial bypass or have an abortion, which is also something that was up there. And that particular piece of statute in New Hampshire has an interesting history. Before, when I realize abortion is a divisive subject, but the statute that's in play on this one originally was determined to have the right of the child, but then it went up to the First Circuit, said that a parent had a right to access. It went to the First Circuit. First Circuit basically reversed. It goes up to the it goes up to the U.S. Supreme Court, and I believe the case was Ayotte versus Planned Parenthood. U.S. Supreme Court reverses and says parents can actually get this information, but then the New Hampshire Supreme Court, not the New Hampshire Supreme Court, excuse me, the legislature reenacts the same statute. So you tell me. Now, there's a couple of other things that can happen here, which whether or not you want to include this language or not, and this is obviously going to be the policy. If you wanted to take a look at whether or not these medical records would be restricted, I'll use that word. I'm looking at lines 12 through lines 14. Under federal and state law, when you look at HIPAA, okay, access to records are going to be available to a personal representative of the patient. So if for some reason you wanted to have parental access to those records which would otherwise not be available, if you deem a parent to be a personal representative, that would be a permissible gateway to be able to get the records that would otherwise not be available. So Now, there's an interesting question here, whether or not, and I don't recall it being a New Hampshire Supreme Court decision, but check me, and I doubt that it is, whether or not somebody who's deemed a person, whether parents and legal guardians are deemed to be a child's personal representative for all purposes under the law or not. Now, that's an interesting question. I don't believe that's come up. So that's the reason why Berg still controls. Okay, however, if that language were in there, those records would be accessible. Bear in mind that on Berg, for example, if we want to make sure that children do have an expectation of some kind of privacy rights, then if we wanted to look at patient-therapist privilege, then certainly a child would have a reasonable expectation of privacy, and it would be unduly intrusive on the child's treatment, okay, if that privilege were violated or was accessible to a parent. So on one point, you have a parent's right to know about the aspects of a child's rights, which affects their upbringing and parenting. And on the other side, you may have a need for a child to be able to have an expectation of privacy in a patient-therapist relationship. So obviously the policymakers have to make that decision. We already have the case of Berg. You could override that by statute if you wanted to. That would be at the discretion of the legislature. So other than that, I certainly support this bill. I think it will certainly help parental rights, and I don't see where it does any harm to anyone. And if there's any questions, I'm happy to answer them.
Seeing no questions, I want to thank you for your testimony.
Thank you.
We did call you earlier, but you weren't in the room, so we didn't forget you. You just said.
I'm sorry, I was otherwise disposed.
That's okay.
He was with me in the hallway. My fault.
You're a bad influence.
If I could ask the folks from Dartmouth one question that I should have asked before, I apologize. I know that there's discussion in different languages that can be used in a potential amendment.
Sure.
One of those was when a parent or legal guardian agrees to a confidential communication between the minor and a healthcare provider pursuant to HIPAA standards for a federal law or regulation. Can you give me an example of what that?
Sure.
We're talking about a parent agrees to something being withheld from them in advance, and then they're trying to request it.
So there may be a circumstance where, I'm just going to give just hypothetical, if I can.
Yes.
There may be a circumstance where mom and dad say this 13-year-old is struggling and needs to access mental health treatment, and is paying for that child's mental health treatment, and they say, you know, everything that happens in this room is going to be confidential. We're not going to, we want you to get the care that you need. Please be honest and forthcoming with your therapist. And that would be the circumstance that's just one that I can think of off the top of my head.
And how is that process executed? Do they sign something agreeing that in advance, and how does that work?
I don't, that's a great question. I don't think that they would have to sign anything. But given just thinking through this fact pattern, there may be a time where they make that agreement with the therapist and then change their mind. And I think that that's where this confidentiality provision would come into play. I'm just thinking through it, Senator. Yeah.
And I think that's why the federal regulations recognize that as well. There may be that hypothetical circumstance.
Thank you.
Thanks.
The only thing I just want to underscore, you know, we very much support this bill and would like to see it move forward in an iteration that's going to make it most practical to implement and ensure parental involvement.
Thank you.
Thank you.
Are there any members of the public present who wish to testify that are here that have not testified already? Seeing none, we'll now close the public hearing on HB 560. At this time, we'll now open the public hearing on HB 273. At this time, the chair recognizes. Is there Representative Representative Drago?
Drago.
Drago? You're not on the list.
I'm not.
Well, the floor is yours anyway. But just please state your name for the record and
Thank you, Mr. Chairman, members of the committee. My name is Representative Mike Drago. I represent the town of Raymond, and I'm here to introduce HB 273, which gives parents access to their child's library records. For a fun little thing you guys could do next time you're at an event in your district, if you ask a parent, did you know when you sign your child up to get a library card, you lose all access to your child's library records? They're probably going to say the same thing that all my constituents say. What? I had no idea that was a thing. When a parent signs their child up, their child's library record is now theirs and theirs alone. And I found this out probably about 2 years ago. My daughter was reading a chapter book on horses. There's a series of them, and I was reading World War II chapter books, a series as well. And we were on to the next book, and I requested both books at the same time online. 2 weeks went by, and our librarian emailed me and said, one of the books you guys requested is in. I said, oh, cool. I was thinking it might have been my book. I was excited to pick it up. So I responded back, oh, what book came in? And she said, well, I can't tell you. That's against the law. And I was like, wait, what? I had no idea. I looked it up. It is true. And what I didn't realize at the time is I accidentally ordered the books on her account, my daughter's account, not mine. And because it was on her account, I was not allowed to know what books my daughter was reading, or in fact, it's actually my book, to be honest, and it was obvious it was for me, but still, because it was on her account, I wasn't allowed to know. But then I took it a step further and I started thinking about it. When my daughter doesn't return the book on time and there's a late charge, I'm the parent. I'm the one responsible for paying the late charge. Taking a step further, if she happens to lose a book, I'm the parent. I'm the one responsible for paying for the lost book, or I have to find it. But how do you find a book when you don't even know what book it is you're looking for because you can't be told? So that's kind of the real world implication that I ran into on this. But there's also the elephant in the room, and that is the inappropriate material that makes its way into our libraries more and more these days. And that debate isn't going to be solved today or tomorrow on what's appropriate for who, but I think it's more important than ever to at least have parents have access to their child's library records so they can help decide what's appropriate and what's not. You know, we all remember Blockbuster or the movie rental stores growing up. You know, you'd walk in the door, the G movies would be in one section, our movies over here. If they had the X-rated, they're out back, you know, so people just didn't happen to see them. Well, libraries aren't like that. Libraries don't have a book rating system. These books that people have issues with are just interspersed throughout the libraries, and kids can pick up any book they want. They can read any book they want. And this bill gives access, you know, allows parents to be able to check in and make sure that the books they're reading are appropriate. And it's important because libraries in the state, they pay dues to an organization called the American Library Association. And that organization does several things, but one of them is it kind of offers guidance on how, you know, how to run libraries. Obviously, it's up to the individual librarians and the trustees, but they put out a thing called the Library Bill of Rights. And part of the Bill of Rights says any person of any age should have access to any book. So any book at any age. So children walking into the library, they don't have librarians saying, hey, that book might not be appropriate. I mean, I'm sure some do, but the fact is they don't have to. And so it's up to the parents, or it should be up to the parents to guide their children. And this legislation gives them the opportunity to be able to do that. So with that, I can take any questions.
So just to clarify your testimony, you were allowed to check out books under your child's account, but then not to verify what those books were?
Yes, technically, because I did it online, they don't know who who logged in or whatever, but yes, it was on my daughter's account. But yes, I was not told what book it was that I checked out. Or I didn't check it out, I ordered it. Yeah.
Any questions? Senator Long.
Thank you, Mr. Chairman. Thank you for your testimony. So with respect to your daughter's library card, did you authorize the library to give her that card?
Yes. So at the time that you authored, that's basically what I'm saying. So basically at the time you, and most parents probably don't know this, but at the time you sign your child up, which for many is a rite of passage. I mean, we all remember getting our library cards. It was a cool thing to be able to go and get your library card scanned. But once you do that, you waive your rights as a parent to having access to that account.
Do you know that statute that does that? Because my understanding, it's just the opposite.
Yeah, it's actually the RSA, it's 201. I mean, I could pull up the whole thing, but basically right now it's court, the only way you can get a library record is court order. And there's like 2 other ones. I mean, I could pull it up on my phone, but.
Okay, thank you.
Yep.
Any questions? Seeing no questions, I want to thank you for your testimony.
Thank you.
This time, the chair recognizes DJ Wither.
Thank you, Mr. Chairman. My name is DJ Withy. I live in Wyndham, and I'm here in opposition to 273. I have some written remarks, but I'm not going to read you through this. Just a little bit of background about me. I'm an attorney. I'm a business person. I'm a library trustee in Wyndham, and but I need to make clear I'm here in my personal capacity. I don't speak for the Board of Trustees. I'm also a former state representative. I sat on House Judiciary, and today marks the first time in 25 years I've been back to the Capitol to talk about a bill. So I don't come here often. Look, this is the Committee on Child and Family Law, so I don't need to remind you about constitutional issues. I'm not going to speak to that. I'll speak to just an analysis of the bill. But I would say this, right? And this is just a reminder that, you know, constitutional rights are not something that you grow into. You get them when you're born. They are a restraint on government. And there are good reasons for that restraint. And those reasons are also community values. So I do not question the motivations behind this bill. I think that they are good. But I approach this the same way I would approach any business proposition that was given to me. I want to understand the problem that you're trying to solve, how the idea applies to it, and tell me about the costs. But I think this is a micro bill. And I use that term because the most overused expression in Concord is this is a solution in search of a problem. And I hate that phrase because I find a bill because I think it more accurately describes what's going on here, because I think that describes the market that you're looking to serve. I'll just mention this very quickly, right? There are 2 main arguments in support of this bill. One has to deal with if you're worried about late charges or replacing a lost book. That one I tend to dismiss, you know, because, you know, for 3 reasons, right? One, there's no evidence that that's actually happening. It was a hypothetical. But 2, and I think, Senator, you pointed it out, 201D11 actually allows, the statute already allows for a borrowing record to be disclosed for the proper operation of a library. And loaning out books, getting them back, replacing lost books is a material operation of the library. So it's not, that argument is not a big one for me. The second argument, though, is legitimate. And I think that that's where I focus my attention on, right? Parents need to be able to understand and know what their minor children are reading. And the bill here does that on its face. It gives parents the right to go in and require, but how does it do it? That's also a question. It says that the parent whose address matches the child is allowed to get the record. And I'll address that later, but that's an important distinction. So on its face, it solves the problem. But, and this was part of the reason why I came here today, when you look at the testimony in the House, they didn't talk about all the ways that you can get access to your child's records. And just off the top of my head very quickly, there are 8 different ways. 4 statutory, 4 non-statutory that you can get them. 1, parents have the control and whether or not to allow their minor child to have a card. So you use the parent's card. 2, you can be a co-owner of the account. 3rd, parents can ask or require their kids to show them their account, and they can see it. 4, parents can ask or require their child to provide the password for the account. 5th is statutory, that's consent. You can just apply consent. And then, the representative is correct. The other 3 tend to be less well used, but they are court order, subpoena, and other state statute. Probably not something that people use often, but this is the Child and Family Law Committee. You understand when court orders and subpoenas are applicable. So the truth is that parents already have several avenues to get the information they need, which tells me a little bit about the market this bill is trying to serve, right? So this is very specifically, and I'm not judging these parents, this is just my honest business assessment of the market segment, right? This appeals to someone that isn't satisfied with the tools that are available, who doesn't want to go through the process of requiring or asking consent of their child, and someone who wants to have a statutory tool in the arsenal to fortify their parents' rights. I think that's a very small market segment. And I base that on my experience in Wyndham as a library trustee, right? But actually, Salem and Manchester, we are all part of the same library consortium. So, our policies are roughly the same. That brings me to the last point that I just kind of want to make is about costs. And there are going to be direct and indirect costs, although this wasn't addressed in the House. And that was actually disappointing because this issue took less than an hour in the House and costs weren't really addressed at all. There are going to be direct and indirect costs. The direct costs are going to vary based on the library and whether they're automated or not automated, the number of staffing, but also the number of parents who make this requests and the frequency of those requests. So if you look at the statute, there's no limitation, right, on how often or how quickly parents can get that or you have to provide, right? So not like 91A, where it says you have to respond within a certain amount of time. In theory, because this bill only applies to the current borrowing, because that's all that libraries actually keep track of is what is out, not your history. Someone could make this request every single day. Is that likely? Probably not. But several times a week? Could be, depending on how quickly your child reads, right? You want to know exactly what's out. So, and there's no set time limit to respond to this, right? So does that mean you've got to do it right away? There are issues that just were not discussed related to costs. But I do know this, is that number is not going to be 0. And it will eventually be quantifiable and it will show up in the operating budgets of your local libraries. And as a business person, I hate glib or anecdotal evidence, like the old war horse. Well, it shouldn't be that much. It's the responsibility of the sponsors of the bill to at least provide you some back of the envelope numbers, right? Give me a best and worst case scenario based on automated or not automated libraries, based on the frequency that you anticipate this is going to occur, right? Because something is better than nothing, and right now, there's no way to quantify that. But the indirect costs are no less real. And I'm going to say this because I heard different themes of this in the House testimony. One of those, an example of an indirect cost, is when you are asking a library to do something beyond its library's specialization. Or another example is if you're asking a library to navigate between conflicting directives. One of the comments that I heard through 2 or 3 of the witnesses, and there were 6 for and 3 against in the House, but through, I think it was 3 of them, it comes down to this theme where it says, this is another example of the government or libraries or schools collectively coming between a parent and their child. That's not what the library is supposed to be, but that's what this bill does, in my opinion. It actually puts a library in between a parent and a child, or between a custodial parent and a non-custodial parent who may have equal rights to the education and religion and raising of their children. It's asking the library to make that determination who gets this information or not, and that's just not something that we track, right? And the next logical argument would be like, well, why is this bill only for custodial parents? If you're equal parents, you should have equal rights. I'm not here to answer that question, but the bill just says it's the address of the parent that matches the child. You're the Family Law Committee. You understand these issues. And my last point when I say conflicting solution, later this afternoon, Senator, you're in Judiciary, you're going to hear HB 666, which is relative to library cards and assessing a penalty for the disclosure of library cards. Well, based on what happens here and how things get amended, but let's say they're not, let's just say both bills pass, you're going to have a head-on collision where you're going to have a parent that has a right to access card, but if they don't know that their child has a library card, because in your towns over the age of 12, you can get a library card without a parent's authorization. In Windham, it's 14, but you're in that ballpark. 666 and 273 is another indirect cost, because those could run head into each other and have a conflict. So while I'm sympathetic to what the bill is trying to solve, I don't think that 273 is a better solution than what we already have in law and non-statutory, and I don't think it serves the market by providing it at a lower cost. And that's my testimony. I'm happy to take any questions.
If I may ask, I believe you said you were been a library trustee for about 20, 25 years?
No, I'm a former representative.
When were you a representative?
99 to 2000 was the last session. So I haven't been back to Concord for 25 years. But I was just elected in November or March to be a library trustee.
Okay. So do you have any information or knowledge on how often, under the current law, that library records are being requested?
I have information about Windham. I haven't asked that from everybody.
In respect to the Windham Library.
Windham, town of 16,000, we have about 8,000 library cards. We have never had, we have it set up, and maybe I want to make sure I understand your question.
How many often are people requesting library records from the library in Windham?
They don't usually ask for these because we have a process set up for these joint cards. And parents but we don't have parents asking.
Not very often?
No, not very often.
All right, so my other question is, and I understand that parents and their children can be under the same library card account.
Yes, sir.
But if a child's allowed to get their own library card at the age of 12 without consent, I don't understand how putting them on the same account is a viable solution, because the child can just go get their own account.
The child can get their own account after the age of 12 in your towns and 14 here, but the other non-statutory and the one consent still apply. So if the parent knows that the child has a library card, they can ask them about that. For the passwords, they can ask them to see the account. They can ask for consent to be able to access the account on their own.
And what would happen if the child says no?
If the child that's between 14 and 17 says no to the consent, this is what I said that you could ask or require. In my view, parents have the ability, right, like my own parents did. They can, even if I didn't want to do something, they had the ability to get me to do something by withholding car keys, by withholding, I guess today it's like iPads or phone time or whatever. So it's not trying to, consent is obviously the easy way, but the parent always has the parental right to require their children to provide them with the information that they want without a bill.
Thank you. Senator Sullivan.
Thank you, Mr. Chair. Thank you for taking my question. So, on one hand, you say that parents have the right to raise their children. Then, on the other hand, you're saying that parents need to get the consent of their children. And then you go into, if they can't get it, then there should be some coercion to make them do it. So my head is a little bit spinning with your testimony. Would you agree? And when you talk about, you said we are born with constitutional rights.
Mm-hmm.
Would you agree that there are times where you age into those? For example, I have a constitutional right to bear arms. Wouldn't you agree there's a time where a child reaches a certain age where that then becomes their constitutional right, but not when they're 3 years old? Would you agree with that?
I would agree with that, but I would also put a different spin on that, right? Because, as I'm sure you're aware, there are other, right? This constitutional right is a right that's embedded in free speech, right? The right to conscience, the right to read is part of free speech. And there are many, many Supreme Court cases that say children do not lose their constitutional rights just because they're children, or they don't lose them at the schoolhouse gate. That's the Tinker case. So there is a recognition of rights. This is about the limitation. Rights aren't just about a person. They are about the limitations on government.
Follow up. So, First Amendment, freedom of speech, freedom to read. But that does not include the freedom for a child to have access to pornography. Is that correct? Are there not consequences if an adult hands a child pornography, even if they've requested under their First Amendment right?
What I am saying, to answer your question, and I believe that I started my testimony by agreeing that that this is a legitimate interest, that parents have the right to supervise what their minor children are reading. Where I disagree with the sponsor of this bill is how that happens. And it's basically, it comes down to cost and putting the library in between one custodial parent and a non-custodial parent who may have equal rights. I'm not denying that there's a right of a parent to supervise and to shield or to help protect their children from material they disagree with.
That's all. Thank you.
You guys can follow up? Perhaps, I'm just asking for your thought on this. Would it be easier just to require parents' consent for children to get a library card until they turn 18? And at that point in time, in order for the parent to sign off, they would also have consent to access the records.
Yes, sir. And that is actually a trustee policy that happens on a town-by-town basis. So a town can make the decision to say no one under the age of 18 can get their own library card. A parent always has to. I have not seen that. But I also will make this one last point related to that, because the representative started off with this, saying, did you know that when you sign your kids up for a library card, you lose your rights? All of that information is in your particular library's policy manual. All library trustees are tasked with coming up with those policies and providing them. It's part of the borrowing policy, it's part of the circulation policy, it resides in different areas, but the same policy that tells you when your child can get their own library card, the same policy manual has a confidentiality provision.
Thank you. Senator Long?
Thank you, Mr. Chairman. So do you believe that, well, in a matter of divorces, both parents may still have a license with that address, correct? So this bill would address both.
Yeah, in my professional life, I'm a chief operating officer, and that, to me, is an operating question. That's a very difficult question, and that's one of those indirect costs where, you have separated parents who may or may not have the same address, who have the same rights, or, but you're only giving access, this bill gives access to one parent.
Right.
And not the other.
Okay. And follow up, if I may. My understanding is there's like 235 libraries that are all independently run. So they're not, I'll take the Auburn. I've been to the Auburn Library. I know people that are involved in the Auburn Library. And they don't have computerized, all their books are contributed. People volunteer to work there. They don't have automated systems. So would this put an onus on them to update that?
It's difficult to say because the bill doesn't say exactly when. You have to provide that information. But for non-automated libraries, yes. In fact, there was testimony in the House to that. The non-automated still use cards, right? That go by the date of when a book is due. And so they would actually have, the process would be, you'd have to try and figure out when that library book was due to see who was taking that book out. You remember the old cards where you signed your name and then they just put it in a date tickler file? So if you were looking for the borrowings of a particular child, that non-automated library would have to go through those cards to find the name and then figure out if there's more than one. You've got to go through all 31 days reading all of the cards and then go through the process. So yes, there is a cost, and that was one of my issues, is that was just something that wasn't discussed, even back of the envelope number in the House.
Okay, thank you.
Thank you.
Seeing no questions, thank you for your testimony and answering our questions.
Thank you.
Is Nicole here?
I didn't realize it had been turned off. Thank you to the chairman and to the senators for hearing my testimony. My name is Nicole Govro.
I am a youth services librarian and an assistant director of a library. I will, however, say that I am speaking here on my own behalf and not on behalf of my library. I mention that I'm a youth services librarian because that means I work with the population who is most directly impacted by this bill. I work with people birth through high school graduation. Most people graduate high school around the time they're 18, but I specify high school graduation because there are students with disabilities who do not graduate until they're older. This bill concerns me for a variety of reasons. Some things have already been brought up. As the RSA stands, one of the reasons that you can disclose library records is consent. There are libraries throughout the state where a parent does need to give consent for their child to have a library card. I worked at one of them until very recently. On that same form where the parent gave consent for their child to have a library card, there was another option which was intended to be filled out with the parent and child working together, although often with younger children was filled out only by the parent, saying, my parent has my consent to view my library records. By filling out that box, parents automatically had consent. We made a note on the child's library account saying which parent or guardian had consent to see that child's library records. It was fairly easy. I currently work at a library where children over the age of 13 do not need their parent to give them consent to have a library card. However, their parent certainly can give them permission, and their parent can be added as an approved borrower. We can also create linked family cards where a parent or guardian has the chief account, their child's card is attached. By having those type of accounts, parents can see things by default. As was mentioned by previous testimony, parents may have the ability to log in if they have their child's library card number and know the password. At a number of libraries throughout the state, the default password is frequently the last 4 digits of your phone number, which if the child does not have their own is probably their parents', and hopefully you know your phone number. If you have the ability to log in and do things like request library books on your child's account, be that on purpose or by accident, you have the ability to see what your child has checked out already. If you are placing a request, you're going through the same system that you would be to see what you currently have checked out to yourself. You may not be able to see history. That depends on what library system an automated library is using as to whether or not it preserves history. You may have to opt into that, or it may not be an option at all. I will also say that while I currently work at an automated library and the previous library I worked at was also automated, before that I worked at a non-automated library, meaning everything was kept in a physical card catalog, everything was checked out with, in our case, index cards. And on those cards, we did not write people's name, we wrote their library card number because everyone was assigned a number, and we stamped their due date. So to find out a child's library card current borrowings, we would need to find their name, find their library card number, and see what we had pulled from the back of the book as the card that was kept in the book when it was checked in, and then look through there. That's a multi-step process. Facing a regular request for a child's library records at my automated library would already take up significant amounts of staff time. While other libraries may not frequently have parents asking for their child's records, I can say from my current library and my previous library, I experience parents asking to find out what their child has out multiple times a day. These are parents who already have the right to see their child's record by virtue of being an approved borrower or otherwise having an approval, an attached card, etc. If multiple times a day I am already going into a child's account, printing out a receipt and handing it to the parent or emailing that receipt to the parent showing their current borrowing, that takes me perhaps a few minutes. At a non-automated library, that would take me significantly longer. I will also say that I am one of only 2 full-time employees at my library. And as one of those 2 full-time employees, and by virtue of that being the assistant director and the director, we also have a number of part-time employees who do not have the same access to the catalog and patron functions as the director and assistant director do. There are days when neither myself nor our director are there. And thus we have only people present on staff who would not have full access to catalog records and would not be able to comply with this request at the moment it was issued, or possibly even the same day. If I have 2 part-timers working on Saturday, they do not have access that I have or that my director has to these records. The next time that it is guaranteed both myself and my director would be in is a Tuesday. We are closed on Sundays and Mondays, and while we are generally in the building working on a Monday, it is also if we are working on a Saturday or working longer on another day, often the day we will take off as not to impact library functions. There is also the matter that children do have rights. They have a right to request information and seek it out. I am 30, so I grew up with the internet. I know others did not. The internet has also changed since I was a young teenager and could look things up, and not necessarily for the better. Misinformation is everywhere, and I would much rather have a child come to the library with a collection that has been curated by a librarian with resources that have been published, and in the case of nonfiction texts, generally looked at by a subject matter expert in what the area of publication, and get that information there, then go on Google or another search engine and find potentially misinformation or be exposed to information that perhaps they aren't ready for, because while children are very good at self-censoring, it's much easier to self-censor if you're looking at a book than it is if you're getting a Google search result and suddenly something pops up. Also, children are increasingly asking things like ChatGPT for answers. I'm sure you've heard by now that generative AI can have hallucinations, which means that generative AI is giving an answer with information it has created on its own. It creates false citations. I talk to at least one teenager a week who uses ChatGPT to do their research. I've also worked with children and teens at a variety of libraries who their desire to find information is merely based on wanting to learn about themselves or their body. Throughout our libraries, we have separate sections, ranging from picture books to adult materials. These are not interfiled on the shelves, they are shelved separately. A child is likely to know what section is appropriate for them. Perhaps they do go out to another section and find a material that was not shelved in the section that is readily considered for their age. Ultimately, I cannot stop them from taking that out, but it was shelved separately. And if their parent or guardian objects, that is a matter for that parent and that guardian to take up with their child and build a relationship of trust with their child so they are able to express their own concerns and share information. Thank you.
Seeing no questions, thank you for testimony. Representative, I believe you signed up to speak. You wish to speak? We are up against the clock. I think they kick us out of here at 1 o'clock. Is that true? And that's when they start, so when do they want us out? Probably right now. Oh, is finance coming? Oh, so I'm the problem?
You're the bad guy.
All right,
Thank
you're
you,
up.
Mr. Chairman and fellow committee members. My name is Representative Melissa Litchfield. I represent the towns of Brentwood, Danville, and Fremont. I rise in support of this bill. I am also a co-sponsor on this bill. It has been brought to our attention, I think several times today, that this bill may have something to do with parental rights. Yeah, of course it has something to do with parental rights. I can tell you right now that when I was listed as a co-sponsor, one of the libraries in my district, the head librarian, along with the head of the Board of Trustees, they reached out feverishly to try and meet with me. And their big objection was the fact that with this bill, that we are going to create issues with them creating relationships with the children that are coming into the library to take out the books. They're building a trust with these children that are coming. This is their words. They're building a trust with the children coming into the library. And in some way, I am going to hurt that trust in some fashion. I was told that when I mentioned some of the concerns I have were some of the books that are out there now, they do have pornography, these graphic novels. They are being purchased by taxpayer dollars. I was told, yes, but you don't understand. These books have been on the shelves for years, but now that we've brought it to the surface, we've given it more attention, and that's why these children want to take out these books. I don't care that it's going to cost a little bit of money to right this wrong. We should not be putting a price tag on the safety of our kids. We should not be undermining the relationship between a parent and a child. And I know in our town specifically, yes, at 14 years old, the child can get their own library card. Well, if my child is suffering through anything and they're taking out books that have to do with mental illness or how to make a bomb or anything, I'd like to know about it as a parent. It falls on my shoulders. So thank you.
Senator Long?
Thank you, Mr. Chair. So with respect to parental rights, absolutely, but this takes rights away from a parent. If I'm a divorced parent and I have all the rights that my ex has, but I don't have the address on the card, I don't have a right to pursue what my child is getting out of the library. Correct?
Correct. I don't want this to come out wrong. I don't know the best way to articulate it. I feel like it's better than what we have right now, right? I feel like we're doing better than what we have right now. And if you feel that there should be an amendment, I think that's great. Then put both parents, that's fine.
Okay. Sounds good.
Thank you.
Seeing no questions, I want to thank you for your testimony. Are there any members of the public who wish to testify? Just remember, we do have to be at. It's not about being hungry. First of all, I have to be in another committee at 1 o'clock. Also, I believe, is finance meeting in here? No, okay. Don't miss me in judiciary. I know one of the, okay.
My name is Denise Van Zandt. I'm here on the capacity of the New Hampshire Library Association. I'm also the director of the Manchester.
Excuse me.
Can you turn your mic on now?
Sorry. I'm Denise Van Zanten. I'm here on behalf of the New Hampshire Library Association. I'm the legislative chair and current vice president. I'm also the Manchester City Library Director. So, hi, senators. I just wanted to offer my services to answer any logistical questions because I did hear some things being said here today that I'd like to help clarify, if you wish. And I do have not a written testimony, but I do have age limits related to other New England libraries, just as an informational piece for you, so you can see where we are with our neighbors. In Manchester, we do go over the confidentiality law when people sign up for a library card, including with parents who sign for their children's card. So the law is made very clear to parents that they're not going to have that access unless they access the account online, which is a way around that particular part of the law. And that's all I really have to say because I don't need to rehash anything on you with your time constraints.
Thank you, Mr. Chairman. With respect to cost, somebody who's not, I'm thinking, for example, the Auburn Library.
Right.
What costs, would there be a cost associated with something like this passing?
There's going to be staff time costs, so there is definitely going to be some sort of an hourly cost. For any library to automate, it depends on what system they join up with. Obviously, Manchester will automate within the GMILCS consortium, so it's more about procedures to enact this in our library. But yeah, there are smaller libraries where they're going to have to go back and cross-reference these, so it'll fall to the trustees to set procedures that are timely.
Okay, thank you.
I could ask, and just a ballpark, but how often are parents trying to request their children's library records?
So I asked my youth services librarian yesterday, and she says it doesn't happen very often in Manchester at all.
Thank you.
Okay.
Seeing no questions, thank you for your testimony. Are there any members of the public that wish to testify? Representative Markell?
Thank you, Mr. Chairman. Yes, Jay Markell, testifying on behalf of this bill and supporting it. A couple of things pop up. I think we've already heard a couple of the arguments as to what parents are able to direct the upbringing of their children, so I think this is an important component of potential rights for parents, number one. Number two is to address, there might be some issue with a parent or legal guardian whose address matches that on the minor's library account. It might be wise if, for example, if you have a parenting plan and parents are living apart, it might be wise for the library to recognize that there might be more than one address for the child if the parents are separated. So that might be something, if you need to amend it, that might be something to think about. Number three is that I looked at the original RSA in terms of protecting library records. Just from my reading of it, it appears on its face that was designed to protect adults from their reading materials and protect their right of access to information and shield that from the public. I don't see anything in the way, I'm suspecting, I don't see anything in the way of a legislative intent that meant to say that parents and children, that parents should not have a right of access to what their children are reading. Number four is that while it wasn't mentioned, while it was mentioned in part from prior testimony, I don't see where compliance with this proposed statute places an undue burden on a library. I believe the chairman correctly asked a number of times, how many times do you get this request? And the answer appeared to be rare, not at all. Number five is that the statute does not specify any protocols for how a library complies. So if it doesn't say how a library must comply, it would be difficult for them to assert that there was an undue burden. It seems to me that if a parent walked in or called and said, can you please get me a list of what my child is reading, they can probably say, sure, come on in and we'll print out whatever it is and we'll just give you a piece of paper. So on that, and the other thing is that it doesn't specify timeliness for compliance. So in other words, sure, I'll have it for you in a week. I'm busy right now. I'll have it for you in some kind of reasonable time frame. And it seems like a library could comply with that without any undue burden. So what I'm really seeing here is nobody who was in opposition to this bill, in my opinion, has stated any real prejudice for this piece of legislation to go forward. I'll enter any questions.
Seeing no questions, I want to thank you for your testimony.
Thank you, sir.
Are there any members of the public present who wish to testify that have not testified already? Seeing none, we will now close the public hearing on HB 273. We have a motion to go into executive session.
I make a motion to go into executive session.
Second.
All in favor?
Aye.
So, because there's only three of us and right to know we can't talk outside this room.
Right.
Anything you want to go over before we have limited time? I did have a suggested amendment for a bill, not one that we heard today. And Representative, I believe I gave you my only copy. If I could have that, if I could have that back, you can just hand it this way. Sounds right.
Thank you.
So, this was for HB 243, and this had to do with the false reports made to the department.
Yeah.
Thank you.
I believe,
Senator Long have one?
of course, I always think I do a good job, but, you know, I think I addressed some of the concerns that I had with it. First of all, I did strike the requirement that the department notify them that, hey, if this is a false report, you can get charged. That's just, I mean, it's the law. The law is the law. And then
Right.
I think the original language in there was a legal standard that I've probably seen before, but I don't think that standard exists in New Hampshire RSA's, so I changed it to, let me see. Yeah, I'm not sure. So the intentional false report of abuse or neglect, which I believe is on, of the original page 1, starting on line 26. This is what the amendment would say. A person is guilty of a misdemeanor, so unclassified, because it didn't say the penalty in the original bill, which I was trying to figure out what would happen if you violate the law. But anyway, if he or she knowingly provides or causes the provision, I mean, that's a typo, but oh well.
You did a good job on this.
How do you know it's not their typo? Of false information of suspected child abuse or neglect. So basically, we have the different mens rea standards. So we put knowingly there. So at least operates under our law. So, which I think putting the language, malicious intent to cause harm. I mean, you're adding additional elements, but at the same time, like, that's not. I'm not aware of that being on any criminal RSAs that I come across. So minus the typographical error, this would at least operate in reality. Whether we support the policy or not is another story. And I struck on page 2, lines 8 through 11, and that has to do with a mandated reporter not making the mandatory reporting. That's already covered under a different RSA, so we didn't need to create that conflict. I don't think we'll exec this thing. We have a deadline coming up of when for fiscal notes. So, because we are limited on when we meet, anything with a fiscal note, we probably are going to address next time we're here.
Okay.
But any questions about this? You don't have to. I'm not going to hold anyone to it now.
Nope.
But I think this is pretty close. There was some talk, and I didn't have it anywhere in my notes, but the bill used professional mandated reporter.
Right.
Is there, that might be changed to say just mandated reporter? I like to think we're all professional, but I think, I'm not sure that professional mandated reporter is defined anywhere.
Right.
I think they meant, someone with a professional license or whatnot. But I also struck if you make the false report to law enforcement, that's, the language I took was for when you file there's an RSA that if you file a false report with the police, I think that's RSA 641:4, so I kind of plagiarized what was already in the law.
Yeah.
So, but I don't think we need to put that in here twice.
No.
No.
That's already set out in there. And if it's any mandated reporter, then we don't have to put the court, social service agent, we don't have to list all these agencies if it's just any mandated reporter.
Right.
Right.
Okay.
So that's the intent of this. Obviously, give it a good proofread since mine had some errors. Is there anything else we want to discuss? We're up against the clock. I know the one about grandparents. I wanted to review that more. That's not an area of law I'm really familiar with, at least in practice. So I know Mr. Markell is, but he had an obligation that day. So maybe you want to have some one-on-one conversations with members of the committee if you can.
I'll be available. I just have to step out for a minute.
Yeah, I got a 1 o'clock.
Just, you used to practice in family law? Or have? All right, so at least he has, and he's a great representative from Atkinson, which is part of my proud district, so. All right, anything else we can discuss today? Anything you want to go over?
No.
All right. Is there any concerns about any of the bills we heard today? I think the library one can be cleaned up a little bit, but not. I think we can, I was thinking that it just, unless you have, if you have legal custody, whether your address is, you should be allowed to get the records. I haven't looked at what they have in Warwick, Rhode Island, where they require consent when you sign up.
I struggle with the parents needing to get consent from their minor children about these things. Like I feel like the world is backwards. Your children get consent from you to do things, not the other way around. Like we don't ask consent to take them to the doctor. They're going to the doctor if they have to. And I just don't understand what universe we live in where children have more access to things. It's our job to watch over them and make sure that they are not exposed to things that they are not ready to be exposed to.
And don't get this crossed up with medical records.
No, I'm just saying that the word, when it keeps saying, like,
Yeah.
testimony kept saying, parents, the children need to consent, even that list that we were given, it says that children have to sign a waiver to consent to their parents. A children's signature has no legal standing.
They need my permission to go to the library in the first place, never
Right.
mind what they check out at the
Well, yeah,
library.
and
So
I think-
I don't, if they want to walk in, they need the.
And Manchester, I think, they don't
So
ask
I
for a
get-
lot of it because there are very few children that are walking into the Manchester Library without a parent with them because of where it's located in the neighborhoods it's located.
But I think the address language, having
Yeah,
the same.
that's
we
fine.
can address that, and then we don't have to make this as, grueling as the medical record
No,
request, but
no.
at the same time.
Yeah. And with the medical request, like, we can talk about that further, but there's some things I agree with the amendment that was brought forward, but the first line of that amendment that was brought forward gets rid of the portal, which is the whole purpose of the bill, so we can't
So I think.
go down that road.
So the issue with the portal is that it's just an online system and they don't have any control. They don't know the software is not set up as between parent and child. It's just basically you signed in. So once you're signed in, you basically,
But they do have control over what gets put into the portal. They can determine what gets put into the portal, and if there are things that are sensitive that are supposed to not be shared with parents, that doesn't have to be put in the portal.
you're right. The problem is that the portal's been up and going already. So they would have to go back.
changed.
No, I know that, but to go back for every child in the system and change it.
But we do this, like, technology changes so fast, right? That we often have to go back and make changes to correct and make corrections. It's just some things that we have to do.
All I'm saying is anything in the portal, you can request the digital copy. Some hospitals or whatever, they'll email you your records request. Some you can get the physical copy. All I'm saying is there's nothing in the portal you can't get, but the problem is the portal, even if there was a abuse prevention order, I'm just saying they have no way to.
So let me give you an example.
I'm not saying I agree with, I'm
Right.
saying I understand what they're saying.
The child has access to the portal, goes on, looks at it, looks at the records. Because I actually deal with this with my mother. If this is still on, she's going to kill me for saying this. But she goes into the portal, right? And then she sees that there are red things. There are things that look like they didn't come out correctly in the tests, right? And I have to have a conversation so you don't get ahead of yourself, talk to the doctor. You've got a child now that goes into that, and they see something flagged that doesn't look right. And, we've seen situations where children want to protect parents and not tell them, and they'll carry that fear and that burden with them and not tell the parent because they don't want to concern the parent, right? But they need someone to walk them through it and explain to them what it is and what these tests mean and what is being said if you look at your own portal, sometimes it's really hard to determine what they're actually telling you, right? But there's also communication in the portal, messages that go back and forth that parents should know what those messages are going back and forth between. You don't know who they're talking to on the other side sometimes, right? Who has access to the messages in the portal?
The point I'm making is to put this policy in place. Right now, I understand the difficulties with compliance with the portal. With the rest of it, but I understand. At least I can understand what they're saying. They may have a hard time.
I understand. We have a lot of things where compliance, has to come into play and people have to figure it out.
But we factor that into our decisions. Yes, if it became law, then they would have to make their best efforts to get there. So
We could, call our federal delegation and tell them to remove some of the federal guidelines. That would help us out a lot too, as far as having access to our kids' records.
It's an option as well.
It is an option.
Right. Is there any other business to discuss? All right.
I'll move to come out of executive session.
Second.
All in favor?
Aye.
All opposed? The ayes have it. Now out of executive session, and we will now adjourn the hearing.
Very good. Yeah, I think.
I like to leave the mic on just because I like to hear my voice radiate through the room.
We all do.
Yeah, I
We
think
all do.
judiciary today is listening, is him.